Good afternoon, everyone. It's 2 o'clock. We're going to reconvene the Board of Supervisors meeting, and we're on item number 26. This is an appeal. This is a community development planning matter. It's an appeal from Jeffrey Fleeman of the Planning Commission's denial of a decision that found a discontinuation or an abandonment of a non-conforming mobile home park use on property zone multifamily apartment. So I think what I'd like to do, unless there's an objection, is Mr. Plemmel, you take us through what's the history of this is, where we are, and then we'll have comments from the appellant.
Thank you, Mayor. For the record, Lee Plemmel, Community Development Director. Good afternoon, Mayor, Board of Supervisors. Yes, as you said, this is the appeal of a decision of the Planning Commission, which their decision was based on an appeal of staff's decision. I'll go through that a little bit. This is regarding property located at 3769 Reeves Street, property known as the Mountain View Trailer Park. Just a little bit of background on this issue, and I just want to go over some, you have the report attached and a lot of detailed information from both staff and from the appellant. I'd just like to give a high-level overview of that. So generally, in the Carson City Municipal Code, these are kind of the two most applicable sections that a non-conforming use may continue. In other words, a use that may not be permitted today under current zoning that was in existence and was legal at the time it was established may continue. So that's the general rule. The next section, another paragraph in that same section about the abandonment of a non-conforming use, and so this is really the point of discussion for this item, is that a lawful use of non-conforming land or building, which is, and key terms, I've highlighted these terms here that they're used throughout and are the key terms. So a non-conforming use which is operationally abandoned or discontinued for a period of 12 consecutive months or more shall not be resumed. So that's the Carson City Municipal framework under which we're hearing this item. So a little bit of background and timeline of events regarding this mobile home park. It was in June 20th of 2012 that we have record that the assessor's office went out to that property and verified that all mobile home parks, all mobile homes, all of the mobile home structures that were on the property had been removed from the site. They were no longer assessing any personal property on that property. So it was no later than June 20th, 2012. It wasn't until a little bit more than a year later, and just barely more than 12 months later, that I got a call from the realtor selling the property. There's an email included in there that the realtor was informed that that use had been abandoned for more than 12 months, and therefore the mobile home park could not be reestablished on the property. Later that year, and I guess based as is in the appeal, there was some conversation with the property owner over this time with the State Manufactured Housing Division, and so they had a similar question of us. So there's a letter included in there that was sent by the city affirming our position of the abandonment of the mobile home park use at that site. And it wasn't until earlier this year that the property owner made contact with the Planning Division staff. I consulted with the district attorney's office at that time and actually had been consulting with them through the process on this non-conforming use, just to verify that our determination in earlier, in 2013 in June was indeed correct. But it was advised that we give the property owner the right to appeal. So this was the first time he had learned of it. The district attorney's office felt, even though the time had long expired, that we should give him the opportunity to appeal, and so he filed an appeal of staff's determination to the Planning Commission. Then on July 30th of this year, the Planning Commission upheld that determination that the non-conforming use may not be continued by a vote of 6-0. In the latest appeal, there's the original appeal included, and certainly the Planning Commission staff report in your packet that has a lot of information. And then in the appeal of the Planning Commission's decision, there's another letter that I also address in a memo in there. But I think essentially there are two arguments: that the property owner intended all along to reestablish the mobile home park and put mobile home parks out there and did not abandon it. There was some weeding and maintenance that went on the property. Won't go in, the appellant can go into the arguments a little bit more there. But as I've noted in the first bullet here, in response to that reply and in consultation with the district attorney's office, again, who's Joe Ward is the Community Development Department's representative, and so he can help me as necessary and answer questions for any legal questions. But in summary, there's a couple citations in the staff report, but in summary, the Nevada Supreme Court has ruled that the intent to use a property for a particular use cannot substitute for the actual use of the property for the purposes of establishing a valid non-conforming use, which is precisely the case in this instance. Second argument is that the city did not notify them that they had abandoned the use, and therefore I suppose the 12 months should start once they get the notification that they have abandoned the use and are possibly going to violate a Carson City ordinance. However, it is also well established, and this second bullet is not intended to be a Nevada Supreme Court ruling decision, although I think it is well established in the courts as a matter of zoning law, that it's the property owner's responsibility to know the zoning laws pertinent to the development of their property, and not the city's responsibility to inform them. For example, if somebody goes out onto their property and starts doing a use that's not permitted, city goes out and tells them that's not permitted, they don't have an argument that, well, before I did it, you didn't tell me I had you didn't tell me it wasn't illegal, therefore I can keep doing it. So we feel that it's kind of a similar argument to that. That concludes my presentation on this, and I'd be happy to answer questions.
Okay. Anybody got any questions? I'll leave before we hear from Jennifer, counsel for Mr. Fleeman. I don't see any. Jennifer, you want to come on up? How's your new office doing?
Good, thank you.
Very good. While you make your presentation, Jennifer, would you speak, if you want to or could, to what you believe to be the date of abandonment, or if there wasn't an abandonment, or the date of discontinuance, or that there was no discontinuance?
I think absolutely, and for the record, Jennifer Mai from My Law, representing Jeffrey Fleeman, the owner of the Flicker Group LLC, the owner of the property. I think that's actually a fairly simple question in our opinion. The property has never been abandoned or the use discontinued, as far as we're concerned, pursuant to Carson City Municipal Code ordinances. And I'd like to start just briefly and make it, respond to the Supreme Court cases that have been cited both in staff's memo and again in staff's presentation today. I have a short handout just to make it easier. If you learn like I do, it's easy to have something in writing in front of you instead of someone talking to you. Our position with regard to the cases is fairly simple. Both cases cited are dealing with how one qualifies as a non-conforming use. So before zoning ordinances go into place, what the use is on the property. And the cases in that case are dealing with someone saying, I'm not using the property like this now. My intent is to use it like this in the future. And zoning ordinances go into place. And at that point, you don't qualify as a non-conforming use. We don't debate that that's the case. Unfortunately, that's not the situation that's in front of us now. Now we have a non-conforming use that no one disputes was grandfathered in. That use was in place when the zoning ordinances went into effect. So I don't believe that those are the cases that are in any fashion applicable to the current standard. I think the more applicable cases, if we want to talk about intent, which is potentially not necessarily where we want to go, but if we're going to talk about intent, I think the applicable cases are those that apply to someone who already has a property right and is about to lose them. And in that case, for example, someone who has an easement and you want to say that they've abandoned that easement. So the easement exists, and now we want to talk about what it is to abandon that easement. In that case, there has to be a showing of actual intent to abandon. And in this case, it would be that planning would need to show that there was an actual intent to abandon this use by Mr. Fleeman. There certainly wasn't. Mr. Fleeman, from the minute he's purchased the property, has been developing it and maintaining it. He's been engaging in all different types of activity to try and put a mobile home park on that property. He's been dealing with financing. He's been dealing with insurance because unfortunately there was a fairly substantial theft on the property shortly after he purchased it, so there was quite an insurance dispute. He's been dealing with contractors. He's been dealing with engineers. So there's been a long-standing course of conduct here to develop this property, and those are normal actions that we would associate with developing any property, and in fact are things that are discussed in the Carson City Code as part of the development code. These are the steps to develop property, and Mr. Fleeman has been engaging in those. In our opinion, the Carson City Code that's applicable, and I believe Mr. Plummel cited that, is Carson City Municipal Code 18.04.030 sub 3, which says that you need to abandon or discontinue for a period of 12 consecutive months. An additional code provision which wasn't cited or wasn't part of the presentation was Carson City Municipal Code 18.03.010, which defines the term abandon with regard to 18.04.030, and it says that abandon means a use not having been developed or maintained. In this case, I don't think there's any dispute that Mr. Fleeman has been developing and maintaining that use since he purchased the property. There's not been a date where we believe that that use was ever abandoned for terms as are defined in 18.03.01. Development has been ongoing and is certainly continuing to be ongoing, this being part of that process. And the other point that I think is worth noting, though it's a little bit less legal, and I wouldn't be citing to you code provisions or Supreme Court cases, this is a good development for the city. This is certainly an improvement upon what's there, which is a vacant piece of property. And at this point, Mr. Fleeman's proposing to put on, and I believe there were pictures that are part of the packet that we submitted, a fairly high-end mobile home park that would be quite nice on that property and would benefit that area as a whole, as well as the development itself benefiting the city. So I think while we're not interested in getting into a long contentious litigation with the city regarding whether or not there's been due process in this case or a taking or whether or not we qualified under this municipal code, what we're interested in doing is working with the city and putting in place a fairly substantial and beneficial development that benefits Carson City as a whole.
Thank you, Jennifer. A couple clarification questions, if I could, please.
Absolutely.
I'm looking at Jeffrey Fleeman's letter of May 5th, 2014 to the Planning Commission. Yeah.
Okay.
You with me? On the second page 2 of that, the second full paragraph, there's a statement made by Mr. Fleeman that says, "I called to inquire why I owed fees on a non-operational facility." Does that indicate to you that he believed that it was discontinued, that there was no business going on there?
Absolutely not. I think what he's trying to say at that point, and obviously I'm speaking for him without him here, but he's dealing with the fees that are enforced by the Department of Manufactured Housing on behalf of the state, and those fees are done on a per unit basis. So you pay fees based on how many units you have on the property. At this point, though, we would certainly not be saying that it's been abandoned or discontinued because the property was being developed. There were no units on the property. So as far as fees were concerned for manufactured housing, what Mr. Fleeman was trying to say was there really were no fees owed. I didn't have any units on the property at that time. We don't dispute that there were no units there then. But our position is that development, the term development, does not turn on whether or not there's a unit on the property. The term development turns on the actions that are being taken by Mr. Fleeman, and certainly at that point he was taking substantial action to develop the property. That being said, he didn't owe any fees to the Department of Manufactured Housing.
And what time was that? What time frame was that he did that?
That there was...
Yeah, that he was developing it? What time frame was that?
He's been developing it since he purchased it.
Okay, well, help me reconcile, and Jennifer, if you could, or if you would, please, the continuing statements of his letter of May 5th, where he makes the statement that, and this is his words, his investigation showed that the conditional use permit for the property had expired due to non-use on June 20th, 2013, although I was never notified of the impending permit revocation. Needless to say, this came as a shock. And then the next paragraph reads, I then tried to sell the property for a use that would be compatible with the current underlying zoning. And that he tried very hard to do that, but he actually got a broker involved and was told that an investment of that type would make no sense there. How does that statement reconcile with your statement or his statement that he is developing the property?
What Mr. Fleeman was doing, he was developing it up until he was informed on June 20th, 2013 from planning that he no longer, in Planning Commission's opinion, planning departments, that the use had been abandoned. And then he acted under that theory. He was never officially informed, and I believe Mr. Plemmel covered that to some extent, which has caused the delay here, but he was informed on June 20th, 2013 by Carson City that the non-conforming use had been abandoned. I believe that's what he's saying when he says his investigation showed that the conditional use permit for the property had expired. He's saying that Carson City informed him on June 20th, 2013 that in Carson City's opinion, the planning department's opinion, that non-conforming use had been abandoned. He then tried to deal with the problem which had been presented to him, and the way that he tried to deal with it was to look at what the zoning was that the planning department was informing him was the case, in this case multifamily use, and since that's not something that he develops, he decided to try and sell it, and he went around and he spoke with several different brokers, and I believe he even talked to several buyers or potential buyers, and fairly quickly discovered that it's simply not economically viable to put a multifamily use on that property. There's no interest by anyone to build apartments there. It's simply not worth the money that it would cost for the rents that would be received. And so following that action by, trying to sell the property for what the planning department was telling him the new zoning was, and discovering that he simply couldn't, he went back to planning, and we ended up where we are today, where they then offered him the opportunity to appeal the decision and made that decision formal, that the non-conforming use had been abandoned, and he appealed the decision to the Planning Commission, and we've since appealed the Planning Commission's decision here.
Lee, was there actually a permit on this piece of property? There was a permit that was revoked, an actual permit?
No, there was no special use permit on this property, so we assume it predates current zoning codes, the mobile home park at that location.
So when he says the impending permit revocation in his letter, he's just assuming there was a permit.
Correct, I believe so.
All right.
Okay, I believe he was learning the process and maybe using some
That's okay.
poor terminology.
Just trying to get it filtered out in my own mind here. Thanks, Jennifer. Okay, Supervisor Minkowski.
Jennifer, the mayor's initial question was, could you give us your arguments for why the use was not operationally abandoned or discontinued? And I heard your argument about abandonment, but I haven't heard an argument for discontinuation of use. And in my mind, the minute the last mobile was taken from the property, that discontinued the use. And that has gone on for more than 12 months. So could you respond to that, please?
Absolutely. I think that we would say that the use of the property as a mobile home park is more than simply having the units there. It would be very similar to our argument for abandoned. Part of having a mobile home park there is having the ability to maintain it, having the ability to improve it. And in this case, that use was not necessarily discontinued. The intent was there to continue this mobile home park use, and as part of that use, there was an attempt made, and it's ongoing, not only to maintain the property, but to improve it, to take off the old units, which is beneficial potentially to everyone, the city included, and put on new units. That is just part of a continued use of the property as a mobile home park. And as part of putting on the new units, additional landscaping, some additional engineering, what turned out to be a need for additional electrical, in part due to the theft. But that is simply using the property as a mobile home park. It's part of owning any business or running any operation is that you want to improve that. You want to maintain it, you want to improve it. And in this case, that's exactly what Mr. Fleeman was doing.
When the property was purchased, in the marketing documents, or I don't know, was it marketed by someone? Was there an indication that there was an existing use on there? Was there anything that indicates it was purchased with the purpose of putting mobile homes back on the property?
There was. The property, when it was purchased from a bank. It was bank-owned. It was a foreclosure property. The bank itself was the one that had removed the units. It wasn't Mr. Fleeman that had done that. So the units were off at that point. The property was marketed to him as a mobile home park. His intent at that point was to use it as a mobile home park, and before even purchasing the property, he had engaged in some financial analysis, looking at how many units he would be able to place on the property and looking at the rent that he could expect to recover with these units on there. So it was not only marketed, but he looked at it as a development project for a mobile home park. There was no indication at that time that it would be subject to multifamily zoning.
Lee, on subdivision maps and subdivision, we have been fairly lenient because of the economy in granting extensions of maps, et cetera. Given there was no formal map procedure and follow-up by the city, et cetera, on this, would this qualify for such a leniency, an extension of the time periods, that sort of thing?
Maybe the district attorneys can listen to my answer and make sure I get it right. That seems more of a legal interpretation question. So by code, you are allowed to grant extensions for subdivisions. By code, you are allowed to enter into development agreements with those subdivision owners, which allow you to make those extensions. So those extensions have been granted under current code provisions. There's not a provision in there for granting, well, I don't know of any provisions in the code for granting an extension of a non-conforming use. Yeah.
Before I go to Karen here, let me just ask a question following up on Supervisor Bonkowski's line of discussion here. Take abandonment off the table for a minute. When was the was the use discontinued in your opinion, and if so, when and why?
Thanks. Our date of discontinuance and abandonment, operationally abandoned being that it's not operating, is when the last of the mobile home parks, the last of the mobile homes were removed from the site. So that was the June 2012 date by our interpretation of the code.
So the last 3 homes, is that a discontinuance? And I'm going to ask you the same question. If on June 2012, when the last 3 mobile homes were removed, does that constitute a discontinuance to you?
No, it doesn't. In my opinion, the continued operation was the intent at that point by the owner, which, as I stated, wasn't Mr. Fleeman, but to sell the property as a mobile home park. That indicates that even the previous owner, who I don't necessarily have the right to speak for, but was continuing this use. They were marketing a mobile home park, and that's what they were selling. Mr. Fleeman bought a mobile home park. He began the process of continuing that development, maintaining it, and improving it.
Okay, so I appreciate your comment that you can't speak for the prior owner, but I guess I'm having difficulty, Jennifer, is my understanding how, in my mind, there's a distinction between offering it as a bank, because it was a bank, I think, owned it back then, right, at foreclosure, how that interplays with an actual intent to operate, because to me, the bank wasn't intending to operate. They might have been trying to sell it, but I suspect they were trying to sell it for whatever they could do with it. But I mean, I don't get out of that they were intending to, even if that is the law. And if I grant you that, intent works, that intent satisfies the lack of abandonment argument. But it seems to me that it was pretty clear that the operations of this mobile home park were indeed discontinued when the 3 last homes were gone. And nobody did anything to this thing. Nobody even started talking about it until Mr. Fleeman came in June of 2013.
My understanding, and I might have the timeline wrong, so correct me if I do, but even if we want to focus on what the bank was doing with the property before Mr. Fleeman purchased it, they did not remove the units until 6 months before Mr. Fleeman purchased that property. So the bank itself never had 12 consecutive months where, assuming the theory that they had no intention of operating a mobile home park, they never had that 12 consecutive months that the code requires. Mr. Fleeman stepped in 6 months into that and began the process again of operating a mobile home park. His intent is clearly to continue that use, and he does it from the minute he purchases it. Even before he purchases it, he begins looking at the financing and the economic climate as to what he would be able to do operating that as a mobile home park. So the bank itself can't fulfill the 12 consecutive months that the code states. You would have to take time that is both the bank plus some of Mr. Fleeman's time to say that that use was discontinued. And in our opinion, Mr. Fleeman never discontinued or abandoned that use.
Did he put a home back on the property?
He did not.
Did he put any money into the property?
He's put quite a bit of money into the property at this point.
What?
I believe he's put in, I believe it's somewhere around $60,000 at this time. He's had to engage in, when he purchased the property, he had put a little bit of money into, the finances. So some funds went there. Shortly after purchasing it, there was a theft of all of the electrical wiring and conduits that were on the property so that you could even put a mobile home on there and get any power to it. So he then ended up in an insurance dispute with his carrier, and there was a fair amount of money spent on that. Some litigation ensued, and so some money was spent there, and obviously some time was lost that he certainly never intended to lose. And he then, once he finished with the insurance dispute, began spending money on contractors, some of which he was sending out not just to prepare and put together bids for the landscaping in the long run, but also to deal with some of the nuisance complaints that he was getting from the city. And also, he had various electrical people look at it. He has some bids from electrical contractors, which are in the packet. He had an engineer do some work so that he had plans put together and some basic development paperwork that he could show to potential investors. So he's put a fair amount of money into it at this point, and had put it in before he even was informed by planning that they believed the non-conforming use had been abandoned.
Okay. Karen, then Jim.
Hi, Jennifer. I have no doubt that Mr. Fleeman has invested in this property heavily. I guess my question lies in, was there a realtor involved in the initial sale of the property to Mr. Fleeman? And how much information did that realtor provide to him at that time?
There was a realtor involved with that purchase on behalf of the bank, and I have not done a full review of that entire packet, so I'm not sure I can fully respond to that. My understanding from Mr. Fleeman is that there was not any information provided that there was reason to believe that the non-conforming use was subject to abandonment or that any period of time had begun to run. And potentially that's an error on the realtor's part. We recognize that. Potentially, there's a claim that may be able to be made there, but we'd like to avoid that altogether and instead move forward with this development.
Good afternoon. When did Mr. Freeman purchase the property? I'm a little lost on that date.
Assessor's records indicate December 2012. Does that sound correct?
2012.
That does.
And which was, December 2012.
I have January 2013, but in that basic window.
Okay, so he purchased it 6 months after the last trailer was moved off the property, correct?
That's my understanding.
And in your package, you have some billing bid estimates, but they're all dated in 2014, and you said he did a lot of work after he purchased it, but there's no proof that he did any work other than what...
Unfortunately, the work that ended up occurring was related to the insurance dispute. Shortly, and by shortly I mean I believe it's a matter of weeks after he purchased the property, the theft of all of the electrical wiring and conduits on the property occurred. So that initiated what turned into litigation with the insurance company as to who was going to have to pay for that. Mr. Fleeman was hesitant to put anything further on the property, start putting units back on, start putting additional electrical out there until he had the project ready to go as a whole, since he had experienced this theft of what was sitting out there. And he's not local, he doesn't have the ability to drive by every night and make sure that everything that should be there is there. But the dispute with the insurance company took nearly a year.
So it took till December 2013, 1 year after he purchased it, to resolve it?
December 2013, January 2014. I'm not sure of the exact date.
And question for staff: if we uphold the Planning Commission's decision, would the property then go back to multifamily? And if it did go back to multifamily, can he then make a appeal to switch it back to the mobile home? And if so, what does that entail?
So that's a good question, and just to explain the process, yes, the property is currently zoned multifamily apartment, which allows multifamily dwellings to be developed on there. The result, so what our position is that the non-conforming use has expired and only uses can be developed on the property in conformance with the current zoning. The MFA doesn't allow mobile home parks. They could apply for a zoning map amendment, a zone change, and special use permit to develop that property with a mobile home park. Is our position as to what they would need to do in order to develop a mobile home park on this site.
If he applied for that, what was the cost? What would that cost? And what is the expectation? Would that be easy to convert over to the mobile home, or is that a difficult task to do? In
terms of cost, I can't speak speak to other costs they may incur in preparing applications. The application cost for both of those, without looking at it in detail, would be roughly $5,000 through the city to go through that process. The zoning would have to be approved by both the Planning Commission and the Board of Supervisors.
But assuming, it would probably more than likely be able to switch from multifamily to trailer. I don't think there's a big obstacle there, is there?
Yeah, I'm not going, I'd prefer not to get into a discussion and analyzing this, speculate on our position, what my position might be on such an application.
The couple of questions. First, has any map application or site design or site plan ever been submitted on this property?
We could not
the
find,
last
no,
one?
we couldn't find I think there's some utility sheds that got building permits over the years. Some of the
But
some of the
specifically
storage on
since the
there.
last mobile was removed?
Since the last mobile, there have been no permits to pull, to do any electrical work or any other site, anything else that requires a permit. So like I was saying, the weed maintenance, keeping the weeds down, removing debris from the site, that doesn't require a permit. But there's been no permits for any work that requires a permit.
So neither the bank nor Mr. Fleeman have submitted anything to the city of any intent to develop the property?
No, they have not. And does your comment tie into that? Would you like to add to that, Joe?
Joe Ward from the DA's office. For the record, just three things. The non-conforming use runs with the land. So regardless of whose ownership this piece of property was in, it just doesn't matter. As far as notice, people are have constructive knowledge of the code, and one thing that I think might help is a definition of mobile home park. The NRS defines mobile home park as, quote, an area or tract of land where two or more manufactured homes or manufactured home lots are rented out or held out for rent, end quote. So that begs the question, was this operationally abandoned or discontinued as a mobile home park? And finally, with respect to Supervisor McKenna's question about leniency, as far as non-conforming uses, Amger second says, quote, non-conforming uses are disfavored, and a policy or goal of zoning is to reduce and eventually eliminate or abolish non-conforming uses. Zoning ordinances, thus, are strictly construed against the indefinite continuation of non-conforming uses, end quote. And I primarily hope that the definition of mobile home park helps shed some light on what the issues are here.
The underlying zoning is MFA, multifamily apartment.
Correct.
What's the master plan designation?
It's a mixed-use residential master plan designation in that area. It's also within a specific plan area, Brown Street specific plan area that has specific policies for development in that area.
And is mobile home park included under those uses?
It is not included in that zoning or listed in that master plan designation.
And finally, are you aware of precedents with discontinuing non-conforming uses on other properties? I can give you one if you don't remember. So for instance, I know, for instance, that non-conforming uses have been disallowed on LI zone properties for outdoor storage if in fact the property was not occupied for a 12-month period, regardless of ownership, regardless of intended use of the property. The grandfathered in non-conforming use was discontinued after 12 months of being vacant. Do you know of other precedents? Has that been the general policy of the planning division to eliminate these non-conforming uses?
Yeah, I can't think of any other specific examples right now, other than I just know that it's not, it comes up. It's not a terribly frequent occurrence that this happens. That's particularly when it's not already to the knowledge of a property owner. Sometimes properties They know they have a non-conforming use, and that use goes away, and they know that use is never going to come back to start with, and it's not their intention to bring it back. So it is something that comes up. I'm sorry, I can't give you any other specific examples.
The property was purchased, I guess, with the understanding that it could be used for a mobile home park. Does the buyer have recourse against the seller for, I don't know, for not telling the truth, that sort of thing? What are the owner's options with this? And the other part of where I'm going is, what is the plan to put a couple trailers on there and say it's a mobile home park, or is the plan to make it into a highly favored place to live with lots of amenities and that sort of thing? What's going to happen? What does Carson City end up with at the end of this? Can he get his money back, or what does Carson City end up at the end of this?
So I think you had two questions. I'll try and answer the first, which is, what's the recourse here? What are our options, assuming that today goes poorly for us? There is potentially a claim against possibly the broker. I don't believe that the bank necessarily would be subject to a claim for any representations that it made, but it's possible that a claim might be made against that particular broker for some type of failure to disclose. That being said, there's certainly some weaknesses, and any type of fraud claim or anything like that can be fairly hard to prove. So there's certainly no guarantee that there would be any success. There's always the potential to appeal any decision here and or make any type of a takings or due process claim. There's the potential to simply say it was a bad deal and walk away from it and just be done. So I think those really are the options that my client has going forward. There's certainly no guarantee to recover his money in any fashion if he's not able to put a mobile home park on it. It's not saleable as multifamily use zoning. No one wants to purchase it while it's zoned like that. So he is at this point stuck with it and left with turning to the courts to try and recover his losses. The second part of your question was, what does the city get out of this? The intent is not simply to put a couple of dilapidated mobile home units back out there and leave it as, what it was beforehand. There's certainly an intent to make this a higher-end mobile home park that would be beneficial to the city as a whole. The intent is to put in quite a bit of landscaping. I don't know that the property's big enough to put in amenities such as a tennis court or pools or anything like that, but the plan is certainly to go out and buy newer mobile homes, put those out there on the property, make it a very nice landscaped area that's very, very nice to look at and will be desirable for that type of living. The intent is to make this a high-end mobile home park that the city can be proud of and that's beneficial to the city.
Does he have to have a manager if there's 10 units, 12 units on there? And where is the break-even economically on this thing? Could he actually make money with that few units in that particular area?
I'm not sure as to the answer to your question about the manager. I'd have to do some research, and I simply can't answer it. He's done the research as to where the break-even is based on the rent that he believes he would be able to get, assuming he had nice units on the property and given the basic rent in the area for the apartments that are there. And I believe that his break-even is the 11 units that he's proposing.
Joe, this is for you. Does this boil down to whether the property was occupied or not? That's the first question.
Joe Orr from the DA's office. Actually, the operative language in the code is a lawful use of nonconforming land or building which is operationally abandoned or discontinued for a period of 12 consecutive months or more shall not be resumed. And then tying that together with the definition of a mobile home park, the question is, was this property that had the 3 remaining mobile homes removed June 20th, 2012, operationally abandoned or discontinued as a mobile home park for 12 months or more?
second question. Not saying that we would, but if we decided in Mr. Fleeman's favor, what kind of precedent does that set?
It can always be argued by any applicant, of course, that there's some precedential value, and it may put the board or successive bodies in the position of trying to distinguish and show that under these unique set of circumstances, what's done today truly isn't precedential. But nonetheless, the argument could be made.
And the last question's for Lee. How many properties do we have potentially that have these grandfathered in sort of scenarios? Do you know?
No, and that's another, no, that kind of goes to the notification. We'd have to do a pretty citywide analysis to look at business licenses and analyze that against zoning. So I wouldn't even want to speculate on the number of non-conforming uses that are out there, though we certainly know that there are a number of them.
A couple of concluding questions here, and we'll see where it goes, Jennifer. But is Mr. Fleeman here today?
Mr. Fleeman unfortunately couldn't be here today. He was out of the country on this date, but we didn't want to continue to delay this issue and wanted to keep this
Okay.
the meeting date.
I did a little research, and the Flicka Group, which is the appellant in this case, is in default at the Secretary of State. They haven't filed since December last year. Reconcile that, if you would, to me about whether or not this gentleman really, or Flicka Group, really has the intent, if they're not keeping their corporate or their limited partnership or limited liability company up to speed. Help me understand how that applies with this gentleman's intent.
That's a fitting question. I had a conversation literally yesterday with Mr. Fleeman, and he was surprised to find out that he was in default with the Secretary of State's office. He had been contacted by another law firm here in town who's his resident agent and was informed that he was no longer in good standing, and if he didn't take some action soon, that he would be losing the rights to that. My understanding is he was truly surprised that was the case and hadn't realized that there were any filing requirements, and that it's entirely possible that the Flicka Group had been in default since before he even purchased it. He purchased the Flicka Group from the previous owners, so it's not an entity even that he initiated.
And just so the record's clear, because I don't want to run into a conflict, that wasn't my office that told him that.
No, it wasn't.
Okay, all right. And then my last question to you is, I've read the points and authorities, the memorandum you handed out, and that speaks to abandonment. And I guess, I might be able to get to the word intent in abandonment, in the strict abandonment theory, but I'm having difficulty getting over the fact that this property was really, the use has been discontinued, and there's been no attempt, other than fixing what the vandals did, there's been nothing done on this property since June of 2012, almost 2 years. And to me, that means, that regardless of what intent was, there's been no use on it. And we've indeed, part of the money he's put into it is picking up the trash on it. So you got to help me understand that a little bit better.
I certainly understand where you're getting hung up, and the code definitely provides abandoned or discontinued. To me, using a business, like anyone else that has any type of an entity, any type of an operation, a business that you're using, simply because you're not selling a product, it doesn't mean that you're not in business. You could be renovating your store and you close it down for some period of time while you're doing some type of construction. That doesn't mean you're no longer operating your store at that point. You're simply improving that. You're maintaining it and improving it and hoping to gain more money down the road by engaging in this process of development. My interpretation would be that use incorporates not simply having a unit on the property and making money from it, but the intent to do that, and not just intent. It's not as if I'm standing here and telling you that Mr. Fleeman, these were his thoughts and this is all we have. He really has been taking action, and he's been doing that consistently for a period of time to try and get this development going and getting units back on there. Unfortunately, he's run into a couple different roadblocks that he didn't expect, and that's slowed him down some. But I believe that all of those actions and his clear intention to continue this use prohibits this from being considered abandoned or discontinued. And if I could take just a second and answer Supervisor Aboud's question that you'd made to the DA's office, I think it's exactly those facts that mean the precedential value for what could come from today would not necessarily apply to another case. This is a unique situation. This isn't a property owner coming in and telling you that, I had this plan and I haven't done anything with the intention of furthering it. We have substantial evidence here of ongoing intent and ongoing actions taken. And so I think that would limit that precedential value to this unique set of facts.
Jim and then, John, I'm sorry, John.
Who's the legal owner of the property? Flicka Group?
The Flickr Group.
Do they have, given what the mayor disclosed about their license, do they have legal standing to appeal this?
I believe that they will be in good standing shortly, so they should have legal standing to appeal it probably within 24 hours. Could be as short as 2 if it was necessary.
Make sure you tell your client, regardless of how they come out, he's been very ably represented here today. So, okay. John, step in the conversation.
In that legal standing question, it happens a lot, especially in California, when you don't have legal standing for whatever reason. The state won't deal with you. People will use it against you in proceedings like this, et cetera. So it may sound like legalese, but it is, when you're dealing with artificial entities, such as a Flicka Group, it means they don't exist. So I don't know if that's something we need to take notice of as a board. And the reason I bring that up is because I would like to cut some type of deal, because this area of town, this probably is a good development there. It's probably will enhance that area. And I would like to find a way to allow this to happen, but to continue on and to have the mobile home parks put in there and have a good use. But that's just my own personal feelings. If we have no right to even talk about it, then we need to know that.
Okay. All right. All right. Anything further to come to the board here? Anything anybody wants to add? Staff? Jennifer? This is not, we're not going to take public comment because this is an appeal issue. It's kind of personal to the parties involved. So we'll bring it back here to the board and see where we go on the matter. So we'll make a motion, see if we can get it seconded and discuss and see what we're going to do.
I move to deny the appeal and uphold the Planning Commission's denial of an appeal of Planning Division staff's decision regarding the discontinuation of a non-conforming mobile home park use on property zone multifamily apartment located at 3769 Reeve Street, assessor's parcel number 008-308-01.
Second.
Motion is second by Supervisor McKenna. On discussion on the motion. Go.
I think it's pretty well known that I am an avid property rights advocate. But even I'm not convinced by the argument of discontinuation of the actual use of this. So that's why I intend to vote against it.
Anybody else?
I'm not convinced of the discontinuation of use either. It just seems to me, I would hope that that Mr. Fleeman would give this his full and undivided attention because it seems like too many things have slipped through the cracks, and so that's my thought.
Okay, well, I think pretty well said things. All right, on the motion, all in favor signify by saying aye.
Aye.
Opposed, nay. Your nay. You got the nays down? Okay.
Your nay.
Oh, I do want an aye.
You're an aye. You're an
I'm
aye.
an aye, sorry, yes.
So what
Want to do that again?
To deny.
Yeah, it's a-
On the motion, all in favor of denying the
Right.
appeal,
Can you,
go.
can you re-vote?
Yeah.
Well, you can because it's not, hang on, it's not, we've been through this before. I
I
mean,
just
the matter is not closed until we say we move on here, but you can
I
re-vote if you
didn't know,
want.
that's why I was asking.
Yeah, you can change your vote if you want, that's fine. So, so on the motion, all in favor signify by saying aye.
Aye.
Opposed, nay. All right, there it is. All right. Jennifer,
Thank you.
well done, okay. All right. Nothing's easy in this world. Okay, let's take up, this is the public hearing on the business impact statement to determine whether or not the business license fees proposed for the medical marijuana establishment impose a direct and significant economic burden on medical marijuana establishments, and directly restrict formation, operations, or expansion of a medical marijuana establishment, and find that a business impact statement has been prepared in compliance with NRS 237. It's on file. I know we have a lot of folks in the audience here today. Let me just say this, that we've read all the things that are attached to the board packet, and I have, so the record is complete. I've got correspondence from Andy Wilson, Walter Marting from WSCC, Inc., Doria Shoemaker of HW Wellness, Vincenti Setterberg, attorneys, Pistol and Stigma, Peter Kruger on behalf of the Nevada Medical Marijuana Association, and Michael Phillips on behalf, and his client on behalf of BioNevada Innovation. So unless I missed somebody, you may rest assured if I called your name off that I think I got, and I got Roy Farrow is also, as I wrote on the, Roy Farrow has one as well. So unless, if I called your name, you may rest assured that your comments have been received by us. You're welcome to come and add anything you wish to those statements. It's pretty clear, however, reading the comments, that there is a direct and substantial impact, and that's what business impact statements are designed to flesh out, whether there is or there isn't. So with that in mind, we'll open the public hearing on this matter and see if anybody has anything additional to say. Huh?
Disclosures.
Oh, disclosures, we got some, I got, yeah.
I'd like to disclose agents in my real estate firm have clients who have submitted applications for medical marijuana establishments. While I will not obtain any direct financial benefit from either a yes or no vote on the business impact statement or staff direction on this matter, I do have a commitment in a private capacity to my agents that some might say could reasonably affect my independent judgment. This agenda item deals with a business impact statement and staff direction for medical marijuana licensing fees and not any individual transactions. Therefore, because my vote on this matter cannot intentionally influence the approval or denial of any individual applicant, and because all members of the general business, profession, occupation, or groups that are affected by the business impact statement and staff direction are equally situated and equally affected by my vote and direction, I believe under NRS 281A.420 subsection 4 that my independent judgment regarding proceedings in compliance with SB 374, which implements the requirements of the Nevada Constitution, is not materially affected by my commitment to my agents or my firm, and I will participate and vote regarding the business impact statement and staff direction for licensing medical marijuana establishments.
I have the same disclosure as lawyers in my Las Vegas and Reno offices have clients who have submitted applications for medical marijuana establishments. And while I personally will not receive any direct financial benefit from either a yes or no vote on the business impact statement or staff direction on this matter, I do have a commitment and a capacity to my law firm that some might say could reasonably affect my independent judgment. This agenda item deals with the business impact statement and staff direction for medical marijuana licensing fees and not any individual transactions. Therefore, because my vote in this matter cannot intentionally influence the approval or denial of any individual applicant, and because all members of the general business, profession, occupation, or groups that are affected by the business impact statement and staff direction are equally situated and equally affected by my vote and direction, I believe that under NRS 281A.420 subsection 4, that my independent judgment regarding proceedings in compliance with Senate Bill 374, which implements the requirements of the Nevada Constitution, institution is not materially affected by my commitment to my law firm or the lawyers in it, and I will participate and vote regarding the business impact statement and staff direction for licensing medical marijuana establishments. Okay, and I apologize, we should have made those disclosures before I opened my mouth, but we didn't. Does anyone want to object that I should have made a disclosure before I even talked about opening a hearing? Okay, I don't see anybody, and so we know. All right, so that we are we're now in a public hearing. Anybody want to speak to it? Staff, you want to start off, or go?
Yeah, maybe. Good afternoon again. For the record, Lee Plemmel, Community Development Director. First of all, I'd like to start by saying that Planning Manager Susan Dorpansky prepared the materials, has been doing the majority of the research. She went home with a bad cold this morning and didn't want to hear for that. So I'm pinch hitting this today, and I'll go over this. The District Attorney Office is going to help me. Susan had some prepared things, so if it's a little disjointed, it's I'm trying to take the information that she had and present it. But I wanted to start by pointing out that we do have two items on that are related on here, just so everybody knows. The first one is consideration of the business impact statement in the public hearing regarding that as you've entered into the record. That's taking action on that today. That, as you said, the acceptance, or however we take action on it, of the business impact statement does not impose those fees that are being considered. The following item is further discussion to discuss what those fees are, and we would have to bring back an ordinance. In fact, by state law, it has to be at a subsequent meeting when we bring back the ordinance for first reading to actually adopt any proposed regulation regarding a business license. So getting a little bit more specific on the process, this process is per NRS 237, where if the Board of Supervisors finds that the proposed rule may impose an economic burden on the business, we're required to do some things, including the start of which is to notify potentially affected businesses and trade groups of a comment period regarding the proposed rule, which we did. We properly noticed the action for at least 15 working days, and sent notices out to all the applicants that had submitted applications for medical marijuana establishments to the state, as well as the Chamber of Commerce. And of course, you have a number of comments in your packet. Your action tonight is to determine, or for this item, is to determine whether or not the proposed rule would be an economic burden to businesses. This is kind of high level, not the real detail of those actual findings, but so that's today's action, is just determine whether or not it does. And if you determine that it would cause an economic burden, what NRS says is that you shall then consider, and this is the list, so simplifying the proposed rule, establishing different standards, or modifying the fee. So that's kind of the process we're looking at. The proposed business license fees, as have been drafted and sent out for comment,
Lee,
are...
Can I interrupt you?
Yeah.
Can you go back over those three items, please?
If,
It was modify.
if it's determined this business impact statement is set up not just for fees, but for other types of regulations that may impose a burden on business. So the board, if it's determined, it says you shall consider, and that doesn't say you have to do one of these things, but it says you shall consider these things, is to simplify the proposed rule. That's probably not applicable to fees. Establish different standards of business compliance, so that's where we may require something of a business that incurs a cost to them, but not a fee, or modify the fee. So I think that's, in this instance, that's probably what you're looking at, is if you determine there's an impact to businesses, you should consider modifying the fee.
So on the statement to the board, we have the alternative, and then we have alternative one that says proposed fees do impose a direct economic burden and do directly restrict the formation, operation, or expansion of a business. And then do not and do not. So if we went with the do directly restrict the formation, operation, or expansion of a business, then we would have to consider one of those 3 bullet points.
Correct. Again, so these are the proposed, let me, okay, sorry, one's too far. So these are, again, yes, and that's that last bullet here. That's the action today, is determine whether or not the proposed fees do or do not impose a direct and significant economic burden on medical marijuana establishments, and whether they do or do not directly restrict the formation, operation, or expansion of MMEs. So as drafted, you could see the proposed fees up there, which range from $75,000 to $125,000 a year. Let me take this opportunity at this point to go over some bullet points that Susan was going to include with her presentation, so this may be a little disjointed, but some points I want to make about how the discussion got to these fees and some other points. In terms of timing of this coming before you now, so they've submitted for state applications. I believe most other jurisdictions have adopted fees so far, which has given us the opportunity to take a look and see what those fees are and kind of compare our fees to those fees. Susan has prepared a couple tables in the back, one with the list of fees, presuming, and some of them are based on a on a percentage of gross revenue, so it's assuming gross revenues of $1 million. Talk a little bit more about that but so then you can see the range, which ranges, and it won't go over it, but there's some that just have standard business license fee. Most have an increased fee up to the city of Henderson, where it's a 6% on gross sales. That's even on $1 million is up in the, depending on the class, $155,000 to almost $200,000 a year. So those are in there for comparison. Something else to note, and I should note, we got together with the district. Well, let's see. I'm going to go through our notes here because I think it's in here. It's worth noting that we're the only jurisdiction in this region where there's Washoe County, but then we have Lyon County, Storen County, and Douglas County around us where they're prohibited. So by Carson City allowing it, we are going to be the place where residents of there come to purchase their medical marijuana, which potentially leads to greater impacts on the city that those businesses would have here. In determining our fees, we talked to law enforcement. With the law enforcement treatment providers, I think that's alcohol and drug treatment provides the court system to get an understanding of potential impacts to the community and how they could be offset by licensing fees. We took into the consideration the testimony received during the legislature in getting the law passed at the legislature that for-profit dispensaries could make up to $5 million annually. So they were saying as part of their arguments that this is a high revenue generating business. So our fees, if it was $5 million, our proposed fees would be approximately 2% of that estimate. We have
the testimony was the average dispensary will be $5 million.
Thank you, Neil.
In getting SB 374 passed.
Thank you. And feel free to jump in, Neil, as I get any of this for your help. Our fee, you'll note that a number of fees are based on a percentage. That's not necessarily a bad idea. However, we propose a flat fee because that's how our code and business license fee are currently structured. And so and I think that's more of a legal issue. I think we would need to change how we do business licenses generally across the board in order to do it that way, or at least that would be our recommendation. We wanted to have, and in terms of where we fall in the fees, we felt that we didn't want to necessarily fall at the bottom end of the licensing fees as the place where particularly, we have a cap on dispensaries, but not a cap on cultivation and production facilities. So we didn't want to necessarily be the hub of northern Nevada for these types of facilities. So those are some other points I wanted to make, and I think unless the district attorney's office has some additional comments at this point, I think I'll conclude our presentation with that.
Well, I'll add to it, because at first I was asked to head up the committee by Larry, and then I had to step down because of the ethical issues for lawyers, and now I'm allowed to participate again. So some of the other things that we looked at is, either way, selling medical marijuana is still a violation of law. It's just federal law, so that was another consideration we had to take into account. And then the other issue is smurfing, which is Colorado and Washington are having huge problems with legally sold marijuana being distributed outside the area. And we think that's an issue for us, since we'll be the hub in northern Nevada. So just add those two.
I guess you got to help me on the logic of, or the analysis of, I get the, where it says it doesn't, there is a direct and significant impact, not the words? There's a direct and significant economic burden, but there's not going to restrict formation. Help me understand how you get there again, Lee, please, or anybody understand.
Well, again, it's up to you to make that determination. I think the rationale for that was based on the testimony of an average annual income revenue of $5 million, that is a relatively low percentage of those gross revenues that's not going to prevent the formation. They're still making enough money for the business. But a fee of $10,000 may impose a direct and significant economic burden. You're able to make that decision in the motion, but I think I'm just trying to tell you the rationale, and also note that, I'll just say that.
Well, I think at the end of the day, we'll hear from others as we proceed through this hearing. At the end of the day, I think that the fees we set, because we're all treading in, any of the counties we've got here, we're all treading in different kind of uncharted waters in a sense. And, for me, and I think I've said it before, is that, the fee should be somewhere related. We have to have some rational basis for making a fee, or setting a fee. And I think that at the end of the day, for me, the rational basis is, what's the effect on your community from a community standpoint? How do you address that? And it's difficult to arrive at that number. And I don't know that I've heard today, I think we've talked offline about it, but I don't know if I've heard today an analysis of that. And I appreciate that it's probably very difficult to do. So let me just leave that out there. You don't have to answer that. If you want to, you can, but I'll go to Supervisor Avon.
Well, this taps into what Bob just said. We allowed for these establishments in good faith, and part of that premise was accessibility for the end user. And I guess my concern in looking at this fee structure is that business will do what business does, and that is pass that cost onto the end user, which would force that business into the next county, which is Washoe County. And so I do see that it does cause a significant impact on the ability of a business to form, operate, and expand, because it would limit their ability to do business. Just my thought.
Okay, and I overlooked on when I was reading off it's kind of my old days of administrative hearings, talking about what we've got in the record here. There's also a letter from, let me get it here, Bill Meyer, Chief Executive Officer of Nevada Organics and Arizona Organics. It's a letter dated September 16, 2014, addressed to planning.
Thank you, Mayor. I will note there were two letters, late material, that were passed out.
I think I got those, Roy
one
Farrow
previously
and Bill
one
Meyer. Yeah, okay, thank you very much. All right, go.
I don't want to get too far into the public hearing, have a public hearing first, but, so if I understand this right, the fees are based upon a question 3 type argument of a gross revenue and a percentage of the gross. Is there any type of limitation on net revenue, et cetera, or are we just going, you pay the fee whether you make a profit or not?
As proposed, the flat fee would be whether the business makes a profit or not.
Lee, is there, your approach to the fee structure, is there a reason you didn't look at using a percentage of the gross revenue? Is there a reason we didn't look at that as a?
Henderson does use 6% of the gross revenue generated annually, and I don't know if that's collected quarterly or monthly. In Carson City, uniformly, with respect to businesses, there are flat fees. There may be an exception with respect to telecommunications companies and video service providers, 5% per statute, a maximum of 5% of the gross revenue generated by those businesses. But basically keeping consistent with the otherwise uniform code provisions pertinent to businesses in Carson City, we went with a flat fee.
I could add to that the current capacity of business licensed staff to audit those. I think in these places where they do have those gross percentage revenues tax, they have larger departments that get much more involved in the business license process. We have enough staff to issue the permits over the counter.
But
are
they not paying a percentage to the state? The dispensaries, are any of these dispensaries paying a percentage to the state?
True, yes, they are all paying a percentage to the state, that's true.
So
Yeah.
it could be monitored by the state, you would get that monitored from them, I mean, you could request it, correct?
I think that would be outside of their authority. They don't enforce our permitting.
Well, and there's that's another issue I'm not sure is totally worked out, is the confidentiality of that information going to the state on a per business. That possibly, but I'm not sure. They've had some discussions about that, of whether or not they're going to even give that information to cities and counties.
Can you elaborate a little more on the figure of $5 million? Where did that come from? And do you think that is for a dispensary cultivation or the production, or how does that divvied up or divided up?
Joe Orr from the DA's office. Max Del Real, who made a presentation in front of this body months earlier, prepared what he entitled State of Nevada Medical Cannabis Economic Impact Report, dated April 9, 2013, an economic impact report on the medical cannabis industry in the state of Nevada, produced for Senator Tick Seger-Bloom, SB 374, and the Nevada State Legislature. And at page 6 of his report for the Nevada State Legislature, he states an average for-profit dispensary in Nevada could gross $5 million in sales, end quote. That's where we got that.
If we're using that figure of 5 million and we look at a dispensary of 5,000 square feet or more, that's like 2.5% they're paying for. I'm trying to get a percentage of what they're paying based upon that $5 million figure.
That's correct. 75,000 is 1.5% of 5 million. 125,000 is 2.5% of $5 million.
Okay. So it's not, the fees that staff is recommending here is based, or assuming, based on the $5 million, is relatively low in percentages if that $5 million would be correct, or if we can, and I'm sure we have to assume it's correct. That's what you did.
Well, we, of course, assume it's correct, and Max Del Real did use the term average, and if the average dispensary does generate that much revenue, then Henderson's looking at $300,000 annually per dispensary in Henderson.
That's because they charge the percentage of the gross revenue, correct?
6% of
Right.
5 million is 300,000, correct?
We've, if I may, Mayor, we felt as a committee, that, or not a committee, but as a group working for the city manager at the time, that it's disingenuous for the companies to say, we're going to make 5 million on average as a dispensary, get SB 374 passed, and then come in and say, oh, we're really not going to make that. I mean, you can't have it both ways. So that's where we use that number.
Thank you.
Karen, go, and then we'll open it up for,
Neil-
it's a public hearing, so we'll go.
Was it ever considered that the 5 million was based on number of card holders in a specific region? I mean, is that figure realistic for our area?
Well, he said on average, you have Douglas County who's opted out. You have Lyon County that's opted out. Story County's not in. You have the lake, which is the richest, wealthiest area in the area, which is Douglas County. So there's not going to be a dispensary up there. So, why I don't know why it's unreasonable. I mean, how you can't. They didn't say this is Clark County only. They didn't say this is Washoe County only. They said the average, he said, and he's the expert in the field, that's what he holds himself out as. He said the average is $5 million a dispensary. He doesn't, again, how do you convince the legislature of this and then all of a sudden come in here and say, oh, foul, we're really not going to make that?
No, I understand what you're saying. I'm just saying I don't know how realistic it is with the number of card holders in the area. That's all. That's my thought.
Well, we're serving 3-4 counties, so. But I don't know. I don't know. That's what he said, And with regard to, if you look at our rates, I read these letters, and they say that the rates are, not our rates, the proposed rates. They say that the proposed rates are way too high. If you look at them, they're competitive. If anything, they're low compared to Henderson and Sparks. We're definitely going to be on the low side, and there's no doubt about that. And with regard to impact to the community, the sheriff, I didn't know we needed him here. Mary Bryan, who's a treatment provider, they all feel that this is going to have impact and cost to them. The sheriff has to protect these buildings. These buildings are sought after. They're going to be they'll have high security surrounding them. But the sheriff still believes that he's going to need extra men to watch after them, make sure they're not broken into, those type of things. So these are all costs that impact law enforcement. So if the board feels like they need elaboration on that analysis, we can elaborate on where we came up with these ideas. But think about it. Every community is trying to figure this out. There is no cookie cutter out there answer. So this isn't like, well, we can just decide. We have to figure out what we think is going to happen.
Lee, if you go for the percentage of gross revenue, how would you track that then? How do we track that as a city?
As a legal issue, going for the percentage of gross revenues, we'd have to modify our ordinance for all permitting. So that's one of the reasons why we were a little hesitant in doing that. We also felt that that was actually unfair to the people opening up because we think it's a higher fee than the fees that are being proposed. So, but to answer your question, what they do in other counties is they have, for lack of a better term, this is what I called it yesterday in the meeting, they have their own little IRS who goes and audits and does all of that stuff. And I don't know if Carson really wants to get into that business.
Thank you.
And it should be noted, one last thing is, the Reno Gazette-Journal stated on May 17th, 2004, in their publications that the average permitting fee will be anywhere from $10,000 to $100,000. So we're well within that. And for anybody to say that, oh, why'd you do this after the fact, or you should have done this before we went to the state, that's also a little disingenuous since this has been in the public. These numbers have been kicked around for months, if not over a year now. And so, we're well within that that number. That was an article on May 17th, 2014.
Neil, if you assume for a moment that there is a direct and substantial effect, which I think that's a given, and you also assume that there's contrary to what you just said, if you assume that there will be a direct impact and it will inhibit creation of those businesses, if that comes out to be a fact, okay? I mean, because we don't know, but if it comes out to be a fact, are we violating either the state law or the Constitution of Nevada?
Well, I would say that as long as you base your fees on what you believe the impact will be to your community, and you have a rational basis for that belief, then I think we are fine with both as far as the fees go. If I understand your question with regard to the constitutionality, your concern might be, are we denying, I'm presuming you're talking about the medical marijuana constitutional provision. The legislature took into account that if you live outside of, I believe it was a 20-mile range from a dispensary, you may still grow your own. I believe it was 20 miles. Is that right? Anyway, it's still set up in state law that they would still be able to have medical marijuana in Carson City if they're outside of that 20-mile radius, which presumably they would be, because Douglas doesn't have it, Lyon doesn't, and I don't know where they'll be in Washoe. So I think we would still be okay under that provision as well.
Okay.
Joe Ward from the DA's office. Let me just add, the charter says equitable standard, and the question is arriving at this fee, was an equitable standard used? The legislature, with respect to the 2% excise tax for wholesale, 2% excise tax for retail, and the 2% excise tax with respect to the wholesale, deals with cultivation and with production facilities. There's a provision in SB 374 that allows the Department of Health to revisit this. And of course, with respect to equitable standard, you could always revisit to determine whether or not things should be changed down the road. Because right now we don't have
Right.
things we don't.
Well, I
we just
guess,
don't
Joe,
have.
I mean, you get to that point where, we can revisit an ordinance. We can revisit the fees based upon what we see to be the effect. And I guess, what I'm concerned about here is that we have, for lack of a better phrase, a de facto prohibition in Carson City by virtue, because no matter how you cut it, when you look at the fees in relation to the surrounding counties, the ones that do operate this, on its face, they look unreasonable. And I got you guys' argument that you can take who was that gentleman, the economic development guy?
Max Del Real.
Yeah. And I know the newspapers here today, I will just reiterate my position on that stuff, and that is that I don't view this as economic development. I mean, I view this as constitutional requirement. It's the Nevada Constitution, whether we like it or we don't like it. It's the Nevada Constitution says that Nevada will have medical marijuana for certain prescribed treatments, and that the state legislature will make a law that implements that constitutional provision. And what I don't want to do is rest on other things like gross receipts and things like that for me tend to look at that as medical marijuana as an economic development issue, because I suspect that down the road, it's hard to, I don't fault anybody down the road. Look, what you're really doing is opening the door for medical marijuana. I mean, Colorado, Washington, whatever, you're really opening that door. But that door is one that is not open here. And we're talking about medical marijuana issues that has a constitutional footing in it, whether it's provided, whether it is, whether it's against federal law or not. And so I'm just trying to figure out, if you can revisit it, what's the starting place that you go? Where you don't prohibit development, but you don't let people get in the door for nothing either, where you may run the risk that you're going to create, that there will be a problem, that we don't have sufficient fees to cover the problem they create. I mean, it's a question of how you hit that target. I guess maybe I'm all wet here, but you can tell me I'm all wet, that's all right.
Joe from the DA's, you're not all wet. I mean, the discussion is also, with respect to Supervisor Abowd's comment about driving the price up for the end user, it's been made with respect to the issue of limiting cultivation. But still, the whereases are listed so to address eventually, if it needs to ever get addressed, whether or not this body did reach the fee using an equitable standard. Trying to create a complete picture. If anyone had other whereases, I mean, there's disadvantages and advantages, of course, but to try to create the accurate picture. As far as de facto or being disingenuous, de facto preclusion, with all planning had to start somewhere, and given the realities, and given, of course, the unknowns, they had to start somewhere to basically get this dialogue started.
I'm with you, and that's what we're all struggling up here. I mean, sort of like trying to be reasonable with a dart, and the law says you're supposed to have some reasonable, rational basis for a fee, and we're trying to get there. Okay, all right. Well, I thought, this is a public hearing, so anybody want to add in or weigh in here where they are? Mr. Kruger, come on up. Good afternoon to you. Saw your partner this morning. She said this was all on you.
Mayor, members of the Board of Supervisors, Peter Kruger, Capital Partners, today representing the Nevada Medical Marijuana Association. Thank you. She was here on dogs and cats, I believe, and I'm here on a medical issue.
Have we really changed subjects? Okay,
maybe not. Thank you very much for the opportunity. I represent a statewide trade association that represents the MMEs, not the patients. And our members have looked at, digested, and believe they have an understanding of the proposed fee structure. And that really is where I would like to just take a minute. Regarding a statement that this municipality would become the hub, I would just say that something that none of us control is South Lake Tahoe in Truckee, California, where product is available, continues to be a product, will be available, and price then becomes a factor. And I believe the correct number is 25 miles, not 20 miles to having another dispensary. And so that's an issue that I'd like you to consider. And I think, Mr. Mayor, I thought you were going, as you would as being mayor, to a place where I would ask this group to consider as phasing in. If you start up at the top and there is restrictions to growth or businesses fail, because remember, the first year of this thing, assuming we're going to probably have a dispensary or two start opening in the state around the first of the year, it's the first year there's going to be a lag time for cultivation, so they're going to have product to sell. They're not going to know really what the patient needs in the way of the type of strain, the type of medicine that particular clientele would need. So in listening to you, and our thought was that we'd ask that the city to consider phasing in by when we really have some empirical data. We have the $5 million, granted the senator who is, in his own mind, the expert of this, but we don't have any empirical data for Nevada and for what this community or any other community will provide. So my only suggestion is, and I'm not going to rehash my letter, is that you look at some kind of phasing in with some benchmarks or something, and when you have the data, you can revisit the issue. One last thing, it's my understanding here in the city of Carson City that your maximum rate on gaming is only $15,000, $10,000 to $15,000 for casino. If my information is correct, if that's the case, we're looking at numbers 10 times that for this brand new, as was indicated, constitutionally approved endeavor. So just some considerations. I think that many of the comments that have been made are to the point, but again, I think a phase in ramping up as opposed to setting a number up here and then saying, oh golly, either we had no takers, and remember, you only get 2 dispensaries. So it's not like that, there's going to be 50 dispensaries here. I mean, just so you know, it is in other jurisdictions outside Nevada, a 3,000 square foot cultivation, or 3,000 square foot, cultivation facility would have about 80 grow lamps, 6 plants per light, and it's not, and the stuff I've read says that an average patient purchases about 1/8 of an ounce at each visit, and we're by law, patients here in the state can have a maximum, I believe, 2.5 ounces at one time. So I think this is not going to be the cash cow that many think it is under medical marijuana. Another recreational use is a whole different thing, but we're not talking about that. So thank you very much for the time, and I'd be happy to stand for questions.
Sure. I think Supervisor Shirk has a question, Mr. Kruger.
Have you looked at the fee structures for the other communities, Henderson and everything?
Yes, sir, I have.
Have you appealed? Did you go to those board meetings?
I did not. I had a representative, because Henderson started off initially, and they were going to be a prohibition, and then they modified their position. The answer was no. I did testify in the city of Las Vegas and in Clark County. And and also Washington County.
On dispensaries, can they buy from any cultivation within the state, or must they buy within the parameters of Carson City?
No, it's anywhere within the borders of the state. And there is some misinformation out there that some people have said that it has to be within the contiguous jurisdiction of, and that's not true. It's anywhere. It can't cross state lines, but it can.
They can buy anywhere within the state.
Yes, sir.
And sell it. So to cultivation, even if it starts late, dispensaries can still buy the product from other cultivations and have that. We don't have to wait for the cultivation within Carson City to supply those dispensaries, correct?
That is correct.
Okay, thank you.
Thanks, Peter.
Thanks, Mr. Mayor.
All right. Anybody else want to weigh in? Mark Turner. Good afternoon, Mark. How are you today?
Great. Thank you, Mr. Mayor. Appreciate the opportunity to comment. I'm not going to be too long-winded here. You've read all the comments. Did you get Mr. Paul Collis's letter on our behalf? I didn't hear you mention his name.
We get it?
Yeah, I think that one should be in the package.
I do.
Okay, great. Thank you. Just a couple points we want to make. A couple of the people that are involved in our group already are operating dispensaries in San Francisco and Sacramento area, and they are averaging about $5,000 to $8,000 per day in those higher populated areas. The number at $5 million would require about a $14,000 per day sale level, and I just don't think that we have the population here to be able to support the type of numbers to get to Neil's $5 million at this point in time.
That was your guys' testimony.
Well, you guys have decided to use that, and I appreciate why you'd want to do that. But as we look at the opportunity for people to cultivate their own product, if they're more than 25 miles away from a dispensary, that is going to take away from the business there. And the biggest concern is with these level of fees that are proposed for our smaller areas here would be the wide discrepancy of pricing of product from the black market to the legal market. I have been approached by a lot of people who have medical marijuana cards, as you might expect, over the last several months about this subject. and I've asked them a lot of questions as well. We expect to have to charge in the neighborhood of $300 to $350 per ounce of flour product for our operations, and it is currently available on the black market in a form that is deemed by the users to be very high quality for $200. So if we are forced to charge that level that pricing level for the product, there will be people who head in a direction of the black market, which does actually create problems for law enforcement. I think the whole goal here is to have people obtain the product in a legal manner and not price it in such a manner that people do head to the black market. If they're using it for medicinal purposes and they need to have it and they don't have a lot of money, they're going to do what everybody else does, shop for the best bargain. And whether it's legal or not, may not, as far as the purchase of it, once it's in their possession, if they have a card, I'm not sure how anyone's going to determine the sourcing of that product unless they carry the bag with the little label on it. So there's a lot of things that still need to be considered along those lines. And interdiction of supply of drugs as a means of enforcement is an abject failure, as everyone knows who's studied it. We need to make sure that the product is dispensed through the legal resources that are monitored by the state, that are governed by the state's rules, that have a very wide spectrum of regulation on them that the city itself is not going to have to duplicate. So I think it's important to keep that in mind. Also, in discussing the business license fee with a number of different people from the legal world, including a former state senator, there are questions of the constitutionality of charging $100,000 per license. So that should be further investigated, and it should be clearly proven that it is absolutely constitutional and not maybe constitutional. That's something that I think everyone would agree on. I think that's about it for my comments for today, and then if you have any questions, I'll be happy to answer them.
The statement was made that these facilities will be impacted by crime, be targets for burglary, et cetera. Any comments on that?
The comments that I would make along those lines are probably not going to be what you would expect. The operators that are part of our group that are operating in Sacramento and in San Francisco have said that they are surprised at the lack of issues they've had. One time they were broken into, they stole a safe that had about $300 in it, and that was it. They didn't even steal any of the product. And another time in the Sacramento store, someone came up in a boat along the Sacramento River, climbed up the thing, jumped over the fence, tried to hatchet the door open. The alarm went off, and they got stuck inside the fence with the barbed wire and couldn't get out before the cops got there. So those are the only two incidents that either of these two facilities have experienced. And so as far as crime is concerned, they have testified that they don't believe it's any more of a target than a liquor store or a bank for a bank robbery. So those are just things to keep in mind. One last thing I want to say is as far as the different types of MMEs that will be operating in the state, the revenues that are generated by a dispensary, a cultivation, and an edible production facility are widely variable. They're not even remotely close to one another. So I think that, we're very willing to do our part and to pay our fair share and to make sure that costs and expenses that are incurred on behalf of the communities are compensated and taken care of by the operation. We look forward to working with the city in the future in all the jurisdictions we've applied to make sure that that's right. If it's not as expensive as they think it might be, and I would understand people wanting to reach a long ways at the beginning to make sure that there's more than ample money to cover every conceivable type of problem that might result from medical marijuana in Carson City and other communities, that the finances are there to do that. But it has been our desire as a group through BioNeva Innovations to engage in a fairly robust type of community outreach program too, that would involve making donations to various charitable organizations that are in town. We would like to be able to do that. We do believe that these fees here could inhibit our ability to do that to some degree. If in fact the $5 million figure is correct, then $100,000 is not an arguable about of money. But at this point, given the numbers, the restricted numbers of medical marijuana cards that are available, we really don't see that going on. We don't want to end up with no cultivation operation and no production operation in Carson City by virtue of business license fees, where if our applications are approved in Washoe County, why would we want to duplicate our facilities here at an additional $100,000 per unit?
Mark, if you don't mind, just trying to assess the community risk. Banking practices, will you be able to take credit cards? Is it a cash business? How will you transport your cash, that sort of thing?
Yeah, at this point in time, it looks like the banking industry is moving closer to allowing that sort of thing. Our company, BioNeva Innovations, did open accounts at Heritage Bank. We cannot do business with those accounts. We were able to write checks to the state of Nevada for our medical marijuana permit fees. We're able to pay our architect through that, but we're not able to actually deposit cash from operations at this point. But I've been having discussions with bankers on this subject for quite a while now, and there is movement in the right direction. It's just going to depend on the FDIC and whether they decide that they're not going to worry about a federal offense taking place by taking money in for a medical marijuana operation, which is still illegal federally for the time being. Did I answer your question?
Well, I'm wondering if the sheriff is going to have to put on 4 new officers to guard transfers, or what? Are you going to leave the money in the
Armored
office?
Car Services work very well for all sorts of establishments in Carson City, where it's a grocery store, a bank, a pharmacy, or anything like that. So we intend to use those services as well as needed to transport cash to and from, or product to and from location A to location B.
Mark, of the models given in terms of fee structure, what relates better in your mind?
What's working right now in Sacramento and San Francisco is a percentage of gross revenue. The operators in Sacramento say it's not a problem. It works out well when they make more money or they have more revenue, they pay more to the state. And when they pay or have less revenue, they pay less to the state. But it's correlated to the exact amount of business, so you know what you're paying. And I would support a similar type of circumstance. And even if it ended up being more than $100,000, that's fine. But we know we have the revenue to pay it. That's the thing that's of most concern. Anything further?
I think that's it, Mark.
Thank you.
All right, anybody else?
Hello.
Hello.
I'm Doria Shoemaker for the record. And I would support a different business fee that would either be similar to Reno, Washoe, or Sparks, because those are our neighbors, and that's what we should be basing our fees off of. We don't want to have prices, as Karen noted, that we pass on to the patient that are extremely higher than our neighbors. That's where they're going to be going. It makes it more inconvenient for the patients in Carson, and this was about accessibility, safe, reliable. I know they're basing their numbers off this quote from someone of $5 million. It's ambiguous. Is that at a 5-year term point in time? And I feel like we're a different unit than Southern Nevada. So tying in that $5 million with the whole state, when we have lower population, tourism, and lower number of card holders. So I don't feel it's fair to wrap us into the whole state when they make up the majority of it. Based off numbers that we have submitted to the state, the dispensary would be grossing at a 5-year mark $2 million. The first year, we are showing a gross of $725,000. So putting a $100,000 business fee on that greatly impacts what we can do for our patients in the community and our overhead costs that will be high the first year. So I don't feel it's a wise choice to pick a business fee based on a 5 to 10 year projection for businesses, small businesses that are starting out. You're putting, you're setting up blocks for them to succeed right off the bat.
Okay.
Oh, and regarding security, I have found in research based in Colorado that we are bringing our security team to the facility, to the dispensary or if it's a cultivation, we aren't pursuing that. But to a dispensary unit, we will have our security on site full-time when business hours are open. And because of that, there's a presence there. So crime has been found to lower in those areas because there is also camera surveillance that's running 24 hours. Our team personally is contracted with Martin Ross Associates, and regarding money, that they do transportation of diamonds and things of much more higher value, and have in place security systems for that type of transportation.
Very good. Thank you. Okay. Anybody else want to weigh in? Good afternoon.
Good afternoon. My name is Bill Meyer. Thank you for having the mayor and supervisors. I operate a medical marijuana dispensary in Arizona. And in fact, some say it is the dispensary that was modeled by the state of Nevada. Senator Sagerblum, Senator Hutchison, and 3 other senators and assembly person was in our dispensary about 2 years ago, about a year and a half ago, I'm sorry. And we opened our doors and opened our hearts. Since then, we have had over 50 people from the state of Nevada, most of them Clark County, but some of them from the Division of Health, that have toured our facility and looked at it. And the comment that we hear, and the comment you're going to hear a year or two from now in Carson City, regardless if we get awarded or somebody else, is, wow, that's not what we expected. Let me give you some real numbers, because when my son approached me roughly 5 years ago about getting into medical marijuana business, I said, you know, we have no data. That's the same thing the state of Arizona was dealing with, and the same thing that you know, many people in the state of Nevada are dealing with. Here's the real numbers. Our dispensary, our program, SB3, not it, can't even remember what it's called now, but we were approved 4 years ago by the voters. The governor stopped the program with a lawsuit. The attorney general stopped the program with a lawsuit. The rationale was, oh my goodness, how are we going to have money in these tough times to police these guys? Well, I'm here to tell you that it already exists, whether there's a medical marijuana program or not. There is an underground. There's an underground everywhere in the United States, including Carson City. Here's the real numbers. We were the first dispensary opened in the state of Arizona. We operated alone with 30,000 patients, 30,000 card-carrying patients for 6 months. We did approximately $3.5 million the first year. We paid sales tax of $102,000 to our community and roughly $300,000 to the state. We paid a business licensing fee to our community of $50. Mayor Wires voted against medical marijuana. He's been in our dispensary. I toured him around. Every month, I drop it by with our sales tax figures and hand them to him, and they're going up. Our card count is now 50,000. You have, I think, 7,000. So you really can't make an extrapolation of what the numbers are going to be. But we will do $3 million. There's about 4 or 5 dispensaries in the state of Arizona that will do $3 million this year off of 50,000 cards. So if you want to look at the pure economics of it, that's the way to look at it. I stand here as an advocate for the patient. And I'll be totally honest, when I got into the business model was, even though it's set up as a nonprofit down there, there's ways to create profits. And that's the reason I got in. We see roughly 120 to 130 patients a day. Many of them look like the people in this room. As people tour our facility from Nevada, they're surprised. Old people, young people, veterans, all kinds of jazzies and crutches and those types of things are the patients we see. I am now an advocate, and I don't want this medication to be at such a price that it does get driven underground, like Mrs. Bood said. That happens. We've been opened since December 22nd, 22 months ago. We have not had a single incident that requires the police. We have never had an argument. We've never had a fight. We've never had a break-in. We've never had a complaint. And I'm here to tell you, whoever gets awarded these licenses, I believe are going to operate the same way that we operate, with integrity, with the patient in mind. We cannot compete with the underground. And, you know, these fees will preclude us from being competitive. I'm all about fairness, and we want to pay our part. I'm delighted that we paid $350,000 worth of sales tax the first year. We probably sold 1% of the marijuana sold in the state of Arizona that year. Most of the rest of it was through caregivers or drug dealers. We've brought some of those people back to our side. They're coming out of the underground and coming to the legal dispensaries, which I believe will make law enforcement's job easier. We have a sheriff down there by the name of Sheriff Joe Arpaio, who is quite famous.
I've heard of him.
Yeah. His motto is don't do drugs.
He's got the pink
underwear and stripes.
Right.
Yeah.
I gotta look at mine. Go.
I've made a couple of passionate pleas to Sheriff Arpaio in his office, talking about the goodness that we're doing and how they're not getting all their revenue stream because the underground is bigger than the medical marijuana program in the state of Arizona. It's getting better. 2 weeks ago, Sheriff Arpaio busted an operation. 22 guns, 50 pounds of marijuana, and methamphetamines, the whole 9 yards rolled up into one. He comes out in the newspaper and said 2 or 3 weeks ago exactly what I've said. He says, you got to give the good guys a chance to operate because they're doing it right. It's the first time he said anything positive in 3 years. So he's on board. And I don't know really how to tell you this outside of, you know, come take a look if you want. Watch the people roll through our doors. It'll surprise you. There's very few hats on sideways and 2 sleeves of tats. We get some of that, you know. But how do we know they're not sick? We don't control the program. The doctors do. And they control it in the state of Nevada as well. So maybe they've got some tightening up to do as well. Maybe that's where the law enforcement ought to be looking, outside of thinking about all the nasty things that are going to happen when you implement this medical marijuana program. It's for real. It works. I've got I see hundreds of patients a week. I talk to them. They tell me about their successes with this. We do business with the Mayo Clinic. We do business with Pinnacle Oncology. We do business with another oncology, Desert Oncology. They send their people there for relief while they're going through life-threatening illnesses. I've become friends of those people. Whether they're getting the therapeutic value that they think they're getting is whatever they think is okay with me. They're sick. They need this medicine. You've got the same people here in Carson City that are sick and need this medicine, and we need to find a delivery system to get it to those folks in an economical basis. We need to be advocates. So, with that said, let me go back one more time and reiterate. I do not believe, and I was there when Senator Sager-Blum said $5 million, $5 to $10 million, and I was sitting with him in this building over here. I was up for the vote in the week, and I assisted with questions with the assembly people and the senators that needed questions answered from somebody's perspective that was in the business. They asked me to come. And I heard him say that, and I just winced, because that doesn't happen. Harborside over in Oakland, which is infamous. I mean, it's the biggest dispensary in the United States. I think they do 12 million. And they've been there a lot of years. I budgeted $500,000 the first year in Carson City, and I'll be dang happy if we get to 500,000, because you only got 7,000 patients, and I don't know how many of them are in, Dayton and Fernley and all these places are allegedly going to be driving in here to buy their marijuana. They can access it in those cities. I do know that. Go to Craigslist and take a look sometime at where you can access this medication. We got an opportunity to help the law enforcement, to cut social costs, to have additional monies to give to charities, to give to schools. And that's the way we'll operate up here, and I know that's the way the other guys will operate up there if we're not fortunate enough to get one of the licenses. Now, $300,000, you got to be vertically integrated in this business to make it work. I don't want to be selling somebody else's medication. I don't know how they've grown that. I mean, you can do all the testing you want, but I know how we grow ours. Where did the testing come from? When Senator Mark Hutchison asked me, soon to be a lieutenant governor up here, he said, what would you want to see in the bill in the state of Nevada? Number one, protect the patients, mandatory testing. There's no reason for anyone to have to take medication that hadn't been tested for chemicals and mildew and spider mites and all that type of stuff. But I guarantee you it's being sold right here in your city right now by the underworld. So help me legitimize this thing. You can legitimize this industry, and you'll have people just absolutely thanking you for allowing this program to go forward. We'll go forward if we get the licenses, but I don't want to go forward with high-priced medication, no money to give to charities, no money to do voluntary things with. I don't know whether you've all read my letter or not, but we have 25 employees, and we got probably, 100 pounds of food or 3 or 4 big tubs every day that our patients bring in to give to poor people. And our people, 6 or 7 of our 25 employees, go down and cook once a week on their day off and feed the needy. So that's what you're getting into. You're getting into good guys. Give us a chance to compete with what is currently out there. And the only way we can do that is to have comparable price medication. If I can buy a car over here for $20,000, one here for $10,000, I'm buying the $10,000 car. So with all due respect, I think the fees are a little bit, not a little bit, we're roughly 100 times what a liquor license is. It's absurd. But thank you.
Bill, let me ask,
Questions?
can I
Yes,
ask you a
please.
question? One, the fee in Arizona that you pay did I get that right, $50?
$50 licensing fee.
And
We pay $5,000 to the state.
And I assume that's done by county or jurisdiction, or are there other fees that are applicable in Arizona? Are they
The
all-
largest fee is Phoenix. It's $1,320 for a use permit. It's gone up to $1,370 this year, one time. And then they have a $75 business
Renewal.
licensing fee. Glendale chose not to do a use permit in the sake of fairness. They set down what their separation requirements are going to be. And they said, we don't want to start making exceptions with that because that's where the lawyers get involved. If you're not 1,320 feet from a school, and if you're not 1,320 feet from a church, and if you're not 500 feet from residential, don't bring us a request for a waiver.
A couple other questions,
Yes.
2 other questions. Are there counties or jurisdictions in Arizona that have not permitted medical marijuana?
No.
Or is it?
They've zoned, to my knowledge, Chandler, Arizona has zoned it out. You put 1,000 feet from residential on it, you can zone it out in any city. Okay, so they've zoned it out.
The question then is, do you know what the experience has been if they zoned it out? Is there any technical information that resulted from zoning it out?
Mm-hmm.
Any good things or bad things from that?
Well, just make sure
It's not
patients,
it's
there's
not
more-
anecdotal, if you can.
I'm sorry. Okay, there's more cards in Chandler than any other city in the state, and they don't have medical marijuana. So if these people are sick, and if they have illnesses, and if this is medication that they should be required to get, some of them are going to have to drive 10 or 15 miles to get it.
Okay. And last question.
Yeah.
The $500,000 figure you mentioned in your budget,
Mhm.
and you indicated that's vertical, you filed a vertical. call it
Vertical integration.
Vertical integration. Is that 500,000 for all the levels, or just the
Well,
dispensary? Or if you can tell me, you don't have to.
We don't intend on growing enough medication to take care of, everyone in the area. We want to grow our own medication. If we have excess medication and we can sell that, terrific. But what we'll do is we will donate that to the dispensary, pay the 2% excise tax, and then pay the sales tax on everything that comes out of our vertically integrated system, as opposed to, that's the fair way to the city.
But the dollar amount, the gross dollar amount of 500,000 represents the entire organization then, or is that just the dispensary?
Well, that's the first, now, we're not going to have 1 penny of sales until June. So, if we have to pay these fees.
It's up front, yeah.
Day one, we got 7 months.
But you've budgeted 500,000.
No, for licensing?
Yeah. No,
budgeted
not for
7,500.
licensing, but for revenues. Maybe I
Revenues.
missed your comment
Uh-huh.
there.
And I think we'll do $1.5 million the second year. But tell me what the cards are going to be, and I can tell you what the revenue's going to be.
Okay.
But
All right.
if Arizona's got 50,000 cards right now, and the 4 or 5 major dispensaries, one of which is ours, is doing $3 million, Senator Sagerblum's comments were way out of line at $5 million. And I told him that. Dick's a friend of mine. So, that's where the numbers came from.
Very good. Any other questions?
Other questions? Thank
Anybody?
you.
Thank you
Appreciate
very
your
much.
time.
Okay. Anybody else? By the way, Bill, if you see Tick, say hello and tell him the capital stays in Carson City. All right.
Good afternoon. For the record, Katie Ryder of Pistol and Stigma. I just want to speak quickly to the concern about increased law enforcement costs. Some of this has already been offset through the state application process. One of the merit criteria that's being evaluated right now is a security plan. So the applicants who are going to receive these certificates already have comprehensive security plans that include full-time personnel. So some of these costs are already being footed by the applicants themselves. I think it's a little bit much to think that we're going to have to hire additional police officers and full-time security for a business that's going to have probably the same amount of crime attracted to it as, say, a casino or a bar or some organization that we only charge $1,000 or less for a licensing fee. So yeah, some of those costs have already been accounted for and budgeted for and will not fall to the jurisdiction. That's all.
Anybody else? Hi, Garrett.
Hello.
Good to see you the other night.
Good to see you. Mayor, Board, thanks for having me. First of all, Garrett Lapierre, local businessman. I have no dog in this fight whatsoever, but I just want to throw out, or cat, or horse, or whatever else.
All right.
Just a couple things I'd like to point out. I disagree with the fact that it's being painted that Carson City won't be the hub. We will be the hub, until Douglas County looks at the money that's being generated. But for the counties, there's not a lot of money besides business licensing fees. So maybe they never do that. Story County is going to look at the same thing. Lyon County is going to look at the same thing. We will get those people here, and they will spend their money here. The number of cards that are in this area will grow. And that, I don't know how much that will grow. None of us knows how much that will grow. I don't care who stands up here and tells you that. No one knows that number. If you start too low, you're going to have a hard time going back up. You're here, their medical marijuana industry is here today doing a good job of trying to keep their fees down. Just imagine what they'll do if you're trying to raise the fees up when you've started at a baseline that's too low. They will send lobbyist after lobbyist after lobbyist. Little math for you. If one patient per month had 1 ounce, and they bought that ounce for $250, and let's say there's 2,000 patients, that comes to $500,000 in monthly gross income, which comes out to $6 million in a yearly gross income. That's gross, so that's not profit. You split that business in half because there'll be 2 dispensaries in Carson. You're looking at $3 million right there. I think those numbers are low. Those numbers are going to have to build and grow. But my point to you guys is I'd like to see you start at the high end rather than the low end, because you can always work your way back down, and you'll have no pushback to work your way back down. I also believe a gross revenue tax is a good way to go too. You know, if you did 10 or 15% on whatever the gross revenue is, you know, that's actually a lot more money than what you're looking at here. So that may not be a bad way to do that either. But just want to throw some of those numbers out. I mean, it just takes a simple math equation and a little addition and subtraction to figure out that there's money there, and even conservatively, there's money there. $250 an ounce is a good deal. Really good deal. And the fact of having an older sick patient, you know, 65-year-old lady that's going to go look on the black market for $200 an ounce because she's being charged $250 an ounce at a dispensary, I don't necessarily believe that. I think that's a little bit of fear-mongering. And if you look at the majority of the applicants, they're business people. They're not stupid. They know the numbers. They see the numbers that are going to be in this business. There's not, to my knowledge, there's not a lot of doctors that are backed in these groups as far as being a part of the group. It's business people looking at cold hard numbers and cold hard dollars. So I think that tells you a lot about what their projections and how they see this industry growing. There will be a lot of money in this industry. So that's my 2 cents. Thank you for hearing me out.
Well, I've been busy. Mayor and supervisors, my name is Kurt Brown. I'm a businessman in Carson City, and my business is alcohol. I see many similarities between this industry and mine in its infancy. Let me tell you about banking. The federal government's given the banks permission to do business with medical marijuana dispensaries, but the banks who are federally, chartered will not do it because the burden of proof or adherence to rules and regulations are put on the bank. So the bank is not going to go through that procedure to certify that their clients are living within the law that the government has given them permission to do. Now, state chartered banks will do business with medical marijuana because they're not federal. I think you will see that change in the next legislature by giving the state of Nevada and or the tax commission the ability to certify those medical marijuana businesses as being certified and within the laws, okay? So it'll take it out of the federal banking hands, and the banks will not have to certify themselves with their clients. Other things that have happened in Arizona are that there are ATM machines on site at some of the facilities in Arizona. Security. As I told you, alcohol is very similar in its infancy to this industry. I've been in business here in Carson City for over 38 years. The only problem I've had with somebody trying to steal alcohol is my employees or ex-employees, okay? Same goes with trying to be, robbed or held up. No problems. Again, the number of cardholders in the state of Nevada is very small compared to the rest of the states that have this business legalized. So when you decide how your fee structure is going to be and how it's structured and what it's going to be, I would say that don't get greedy. Grow with the business if it grows, and be satisfied with being a partner. Thank you.
Good afternoon, Mr. Mayor, Supervisors. Trying to predict the overall, I'm sorry, Kerry Richardson for the record. Trying to predict the profitability of the industry, particularly in its infancy, is something that I don't think anybody here is capable of doing. I know I certainly am not. Within our group, there's a wide range of individuals that really approach it more as I do from a small business owner that realizes when you start a new business, it is hard. Particularly right out of the gate is very hard. You've got your construction costs, you have all your other fees, and particularly with this industry, you can't open your doors right away. It's going to be until summertime until you're able to actually start to sell product. That's a very long time to cash flow a business that's in its infancy. We also have members of our group that look at this as a printing press for money. Once things get going, we're going to be all retired quickly. There's all kinds of money. Look at all these fantastic numbers.
What's the theory on how they think that happens? I mean, because I think that gets to my question about whether it's economic development or not. That's what I really I'm curious about that. I mean, what's the theory on saying, hey, we're going to just make a whole lot of money on it? I mean, when the cards are 7,000, you've got a limited amount of cards.
Mm-hmm.
What are people thinking when they say, well, hey, this is going to be a printing press? What are they thinking?
What they're thinking is, first of all, you've got the reciprocity, where you you're accepting cards from other states, and particularly down south, where you have this huge influx of tourism, that is going to have a huge effect on the overall demand. And the fact that currently you only have a small amount of card holders, that is going to change significantly. One of the problems with the industry is that the numbers are tightly guarded, and it's been a very short period of time that the money and the records have been public. So it's very difficult in order to understand the trending and extrapolate from the data that is available, because the data that's available is very limited and relatively new. I think the other feeling is simply seeing what's been happening in the black market, where the black market, this has been very profitable. So the idea is that when it is done and legitimized, that a similar demand overall exists for this product, and that there's going to be a lot of opportunity to make money. I think all of us feel that eventually this is going to be a very profitable business. The states are going to benefit from it, the local municipalities are going to benefit from it, and there is going to be money to go around. My concern as a small business owner is right out of the gate. A tremendous amount of cash outlay in order to get up and running, a delayed time frame from when you can start selling your product, and if the fees are so high that it puts too much of a burden on top of this already heavily burdened industry in its infancy with all kinds of various issues that have to be managed, that's just too much. That needs to grow as the industry grows, as was spoken to previously. My recommendation would be to throttle this back. This is too much out of the gate. Ideally, put it as a percentage, but put the provisions in there to grow as the industry grows, but not too heavy out of the gate. The other thing to look at, you look at edible production, and I see production, I think of these visions of this manufacturing facility and this crazy production area. Production in this case is a small little commercial kitchen. You're talking about taking basically leftovers from the process and making butter out of it that you can put into brownies or infusing goldfish. It's a very small operation. $100,000 to tack on to the production is a huge amount of money considering what is actually produced out of there. We're trying to be vertically integrated. That's the direction that we've been given here. It makes it very difficult to be vertically integrated with these types of fees. So my recommendation would be to grow with the industry, throttle these back, either put it together as a percentage or opportunities to increase, but give the industry an opportunity to get started, give the business owners an opportunity to make some money so they have money to pay these fees.
Thanks, Gary.
Thank you.
All right, other public comment? Anybody? Getting a little long. All right, I don't see any, public hearing still started here. Before we close the public hearing, we're going to see if we can come to a resolution on this issue and then take a short break if we can, and then pick up the next one. So, question.
I have a question for staff. I'm still not clear on our ability or inability to charge a percentage of gross for a business license. Are we prohibited from it, or would we just be required to change our ordinance so that it is equitable?
Joe Ward from the DA's office. You know, there is a percentage of gross revenue charged, and I can't think of the code provision right now, for telecommunications services or providers, for those, in effect, a franchise. There's a franchise fee, isn't it? Not a business license, but in effect, a franchise fee. And there's a statute that also allows up to 5% of gross revenue to be charged to video service providers. I haven't done the research, and I can't give you an answer just shooting from the hip as to whether or not this is something that, given the number of dispensaries too, or perhaps MME establishments besides dispensaries, something that could be done. I don't know. I'd have to do the research.
Jump in on that. So Randy and I's concern was there's case law that indicates that it can look too much like a tax. And if we're taxing, that's what we can't do with our fees. And I'm not throwing Henderson under the bus. I don't know how they did it. I don't even know if these guys went down there and debated with Henderson. But the theory of that case says your permits cannot be tax-based. They can't just be a revenue driver. And for the record, I never said it was maybe constitutional. I said if you determine it's rational, it is constitutional. So it's not, that's the concern. And then what Lee's concern is from a practical perspective is that, or community development, from a practical perspective, is who is going to go down there and audit the companies. I mean, I think these are all great men, and I'm not suggesting that they're going to not pay their fair share, but the taxpayers, I would think, would expect our government to, if we're going to charge a 2% fee, to have some type of audit trail of that 2% fee. And so he doesn't have the manpower to do that. And so that, I think, was a practical issue for him. From a legal perspective, we're concerned that it looks like too much like a tax, and we would have to change other ordinances. But here's a thought, is if your concern is it's too much up front, how about you graduate it? The first year, $25,000, the second year, $35,000. I don't know, whatever numbers you feel are appropriate that also continue to help the businesses grow and cover the costs associated with this. I just food for thought.
What I'm really after is whether we can do it or not, the knowledge of whether we can do it or not. I'm not a proponent for it or against it. However, I have some very significant concerns about trying to charge a percentage fee for licensing for production and cultivation, because as we've heard today, if a MME operator is vertically integrated, then they may donate the product that they grow specifically for their dispensary, in which case there's no gross revenue. So I can see a flat fee on production and cultivation and maybe a percentage fee on the dispensaries, but I'm not clear on whether we can do it or not. And I can see by our chart here that City of Sparks is doing it, Washoe County is doing it, Clark County is doing it. Yeah, it seems like North Las Vegas is doing it. So there must be, anyway, I just would like to know if we can do it and how it would work, irrespective of the fact of whether or not we have the staff to do it.
Joe Ward from the DA's office. In discussing this with Randy Munn, there was a look at Henderson, for example, or perhaps other jurisdictions that do use percentages. In Carson, uniformly, without dealing with a franchisee, you've got flat fees, and that's one of the driving forces to keeping this as a flat fee, not stepping out of that uniformity and going into an area where it's kind of an aberration. But that's the struggle with uniformity in Carson City and creating an aberration.
To answer your question, sure, we can come up with a legal argument to do it. But what we're saying is the reason why we did this is because of the concerns that we're sharing with you. So I know that's a crummy answer, but that's the law. That's just the way it goes. We can do it, and we can come up with arguments to do it. However, my concern is its appearance of a tax and things of that nature, which I didn't really want to say in case you guys were going this way, because that gives them arguments down the road. I think, I'm quite frankly shocked that we're getting balked at for these amounts when you look at what Henderson's taking. I am. I don't mean to throw another municipality under the bus, if you will, but 6% is a huge amount, and I think that looks like a tax. And I think Carson City folks are anti-tax, and that's my concern. That's why our committee came to these numbers, or this idea of flat.
Okay, my question then is, and I guess maybe it's semantics. Oh, Bob, were you going to?
No, go ahead.
Sparks has it structured as a gross revenue fee, basically. So $5 for every 1,000 in gross revenue over 10,000. So it allows it to grow as business grows. There's not a percentage there, so I don't know that it necessarily qualifies as a tax, and they have to pay to the state. So auditing wouldn't be necessary. It's reported. So I would think that monitoring this would not be an issue.
That was Lee's concern.
Yeah, thank you. Yeah, not to add to that, but to add to this discussion and concern and thinking about the timing of getting these fees, I guess a question is this, is if we totally change the method that we're collecting fees, will we have to go back and start this business impact statement over? I think that's more of a question that I'm right now directing towards legal counsel, but knowing that in November we're going to have applicants coming to us to pay a business license fee, and at this point we could not start this process over and have fees adopted at that point, so that's another consideration.
Well, suppose you put it in, to play off what Neil is saying, suppose you put it in at, say, 25,000 for 1 year only, and it has to be revisited, and that by then we revisit it when we know what the 2.5% of the state number is, so that we have concrete data as to what's really happening in that market. But I didn't know, Jim, I'm sorry, Jim and then John.
But if I understood earlier conversation was we would not know what the state collects, that would be confidential. Is that correct? Or would we know what the state collects?
Well, I think what I said earlier is we don't know the answer to that question. They've made a big deal about confidentiality of information on collections and things. And in the ordinance, in the next item, we're going to discuss confidentiality provisions in the ordinance so that we are able to get application information from them. But I don't think anybody here can represent what the state is and isn't going to allow us to see. But apparently it has worked other places. If that's the way it's done, the businesses will do it. I just don't know. That's not how we've done it, so I'm not experienced in
But
doing
the presumption is that if we charge a lesser fee and then increase that by the sales of the 2% that they pay the state, but we don't know if we have access to that to increase the fees later. So we don't know what the businesses will generate, whether it's $5 million, as stated earlier, or if it's down to $20,000 a month.
What I'm saying, relying on the state to give the information to us, we can't guarantee that, because as they report it, even now, as they report, even the applications. So in like Clark County, they'll say how much revenue or how many applications, and they do the same thing in Colorado. So like a big area like Denver, they'll report how much comes out of Denver. But when they get the rurals, at a certain level, they stop reporting individually, because what they don't give out is how much individuals are making. They'll group it together and say how much sales tax revenue is it, but they're not reporting publicly reporting how much each business is. So I don't know the answer if that's something they will give to us. If
The presumption is we should move forward thinking they won't give it to us, I would think. So I don't know how you can presume to increase the license fee based upon a figure that we may not know. We
wouldn't recommend adopting an ordinance based on that without knowing that we can get that information.
Is there a reason, the reason you looked at a flat fee was rather than the percentages because of the complications of having the percentages, that it may be against the state law or something? Or is there any reason we didn't consider it?
From the business license side and collecting that fee, that's what we recommend, because that's how we do it for business licenses now. And it's right, yes.
For the record, we did consider it. It's just, we felt like there might be some legal issues, and I'm not saying what the other counties or cities did was wrong. I'm just saying we felt that there was some case law that indicated that it wasn't favorable, given our ordinance structure.
So where we're at on this item is that we have to decide whether these fees impose or restrict formation, operation, or expansion. And if we decide that, then we go on to the next item, and then we can start talking about dollar amounts. Okay.
Yeah, that's where we're going to go. I mean, we're kind of wide-ranging discussion here, but that's what's up for. So let's take your advice, and we'll decide whether or not this has it's pretty clear that it has an impact, but the question is whether or not it directly restricts formation, operation, or expansion of medical marijuana.
I'll make a motion.
All right, we're on. Anything further to come from the public before we make a motion? All right, motion's in order.
I move that we make a finding that the proposed fees do impose a direct and significant economic burden upon a business and do directly restrict the formation, operation, or expansion of a business.
Motion in a couple seconds. On the motion, discussion?
Yes. And maybe I should have brought this up earlier, but in some of the letters, there were some objections to some of the content of the business impact statement. And on page 2 of 5, which is actually page 3, the document page 3, which is under adverse effects, so it's 2.A, there are bullet points. 17 bullet points. And I'd like to hear, I didn't hear anybody, although it was in the letters, I didn't hear any of the applicants that came up here today address that. So I'm just wondering if that's a concern to them or not, the language that's in the business impact statement. Because from what we heard initially, if we find that the proposed fees do impose a direct and significant impact and do directly restrict the formation, operation, and expansion, then we also have the ability to revise the document. So does anybody have any concerns?
Yeah.
Well, we're on a motion here, so, I mean,
You can't call.
You know, we're in a public hearing, but I think because we're talking about the next step, we can take that up when we talk about, if this motion passes, we're going to talk about the dollar numbers and also the ordinance language, so we can pick it up then.
Okay.
All right. On the motion, further discussion?
Yes.
Discussion's in order.
I know
sorry, I apologize. And Mr. McKenna's motion, we did not clarify it was medical marijuana establishment, we just said businesses. Is that acceptable?
I understood it. I think from what I understood the motion to be, read off the recommended board action, with the exception of, remove the word for not from directly restrict formation. That's what I understand, Jim.
Okay.
Did I miss the motion?
Well, the business impact statement is specifically on medical marijuana.
Well, that's what it is, I know, but I got it.
If I'll change the word business to medical marijuana establishment if you want, that's just,
Well,
we're talking about medical marijuana establishment,
Okay.
so.
All right.
But that's what I meant.
all right, on a motion, further discussion? Hearing none, all in favor, signify by saying aye.
Aye.
Opposed, nay, carried unanimous. Okay, that's it. Now, we're going to take 5 minutes, really quick. Everybody think about what you want to do on the next item, and we should be able to hopefully move through that one fairly quick, because we've heard a lot of information today. So, all right, we're in recess for about 5 minutes. staff direction regarding medical marijuana establishment business licenses, and to assist staff in preparing an appropriate ordinance amendment to bring back for review and action. So, probably, wait a minute, Neil or Joe? Brad and I have disclosures on the record. Do we have to reread those, or could we reference them by, what do you want to do? I mean, I answered my own question. We need to do it. Okay. Disclosures in order.
I gotta find it.
Yeah. I'll go. Lawyers in my Las Vegas and Reno office have clients who have submitted applications for medical marijuana establishments. While I will not obtain any direct financial benefit from either a yes or no vote on the business impact statement or the staff direction on this matter, we've already done the business impact statement, I do have a commitment in a private capacity to lawyers, to my law firm, that some might say could reasonably affect my independent judgment. This agenda item that we're dealing with now, dealing with potential staff direction for medical marijuana licensing fees and not any individual transactions, that deals with that. Therefore, because of my vote on this matter cannot intentionally influence the approval or denial of any individual applicant, and because all members of the general business, profession, occupation, or groups that are affected by the business impact, that are affected by the staff direction, are equally situated and equally affected by my vote and direction, I believe under NRS 281A 420 subsection 4 that my independent judgment regarding proceedings in compliance with Senate Bill 374, which implements the requirements of the Nevada Constitution, is not materially affected by my commitment to my law firm, and I will participate and vote regarding the staff direction for licensing medical marijuana establishments.
And I'd like to disclose that agents in my real estate firm have clients who have submitted applications for medical marijuana establishments. While I will not obtain any direct financial benefit from my staff direction on this matter, I do have a commitment in a private capacity to my agents that some might say could reasonably affect my independent judgment. This agenda item deals with the staff direction for medical marijuana licensing fees and not any individual transactions. Therefore, because my vote on this matter cannot intentionally influence the approval or denial of any individual applicant, and because all members of the general business, profession, occupation, or groups that are affected by my staff direction are equally situated and equally affected by my vote and direction, I believe under NRS 281A.420 subsection 4 that my independent judgment regarding proceedings in compliance with SB 374, which implements the requirements of the Nevada Constitution, is not materially affected by my commitment to my agents or my firm, and I will participate and give staff direction for licensing medical marijuana establishments.
Okay. Staff, what direction do you want? All right, just make sure everybody's still awake after we came back here, okay? So, rather than take public comment at this time, we've had a lot of public comment. We're going to have some board discussion here to see what we can do and see if we can get some resolutions here. And so, John, you want to start? Yeah. Then we'll go from there.
I'll start. Taking Mr. Lapierre's math to heart and looking at things and applying factors such as cost of sales, cost of operating, et cetera, reasonable profit for the amount of risk involved for going into a new business that may or may not be a sure thing. I propose that the fees be 10% of the fees already stated in the business impact statement. So, for example, for less than 2,400 or less than 3,000 square feet, the fee would be $7,500. 10,000 for $49.99, and 12,500 for 5,000 feet plus. There's been no showing that there's been allegations, but there's been no showing of fact that there will be significant cost to the city for having these establishments. And I think being a business-friendly community is more important. As far as, can you flip that chart back to the three things that you had? As far as hold harmless, I think we ought to do what Washoe County has done hold harmless wise, or whatever makes us, puts the burden of this business on those people that are going to go into it to indemnification, et cetera. Confidentiality provisions, whatever is needed, and others. I would have in there a statement that this is a business license fee and that it may or may not be adjusted based upon circumstances of actual operations after the business is known.
just to clarify, you also intended that to be 10% of all the other fees on that chart? The $10,000 for production and $7,500, $10,000, and $12,500 for the different square footages of the cultivation facilities?
Yes.
Okay, and then in addition to that, in the ordinance, on page 1, continuing on to page 2 and 3, there are many whereases. And what I would like to do is to eliminate all of the whereases that are not proven to be factual in nature. So in other words, the first, second, third, fourth whereases are fine, but when you get down to 5, 6, 7, 8, 9, 10, 11, 12, 13, and 14 and 15, I'd like to eliminate those.
I would just like to add on that note that if we're rewriting this somewhat, that we take a look at Washoe County's documentation for their ordinance. It kind of summates a little better, taking out some of the conjectured statements, and it's a good reference. We don't have to reinvent the wheel here.
Right, and I would point out that those whereases are from opponents and proponents. They're not all just from opponents.
So let me see if I understand this correctly. You want to eliminate some of the whereases, the ones you just read, because you don't think they're factual?
Because there's not documentation that they're factual. I can't say whether they're factual or not, and I think that an argument can be made either way, and I would like to avoid the argument by taking them out and just leave the items that are proven to be factual.
And which items have been proven to be factual, and how do we verify that it's been proven factual?
Whereas 1, 2, 3, and 4. And then on the second page, starting with whereas, well, the fourth one from the bottom, currently the Carson City Municipal Code does.
Number 5 is right out of the United States Code, actually. That's how they define a Schedule 1 controlled substance.
Okay, then we can leave that.
So 1 through 5.
Right.
So 1 through 5 is factual.
And then eliminating all of them until the fourth from the bottom on page 2, which has to do with zoning, equitable standards, business licenses, regulating licenses, zoning, that we're doing nothing inconsistent with state law, and issuing of business licenses.
So it'd be, if you numbered those, it'd be 16 through 22 would be acceptable, and 6 through 15 would be stricken.
I'll take your word for it.
Correct? Is that right?
I didn't count them, but
Is that how you, okay, well, need some verification. I'm not sure how we went from 100,000 to down to 10,000, and we don't even compare to the other counties and the fees that they're collecting. I mean, we're going to be in such a low end as compared to all the other counties who are doing the same similar things that we are, and they're going to collect way more than we ever will. And I mean, to drop from this percentage down to 10%, I don't recommend this at all. I mean, I think we should look at and still continue down the pathway of looking at a percentage as other communities are doing as well. I think that's fair. I think dropping this down to such a nominal fee when other counties have already demonstrated where they're at in their fees, and we're dipping so low below them, I just think it's a bad move.
Jim, we agree. What I'm thinking of is, I'm just looking at the city of Henderson's model and how they've they've included a vertical integration. So there's a class 1, a class 2, a class 3, depending on cultivation and dispense in the same location, cultivation, production, and dispensary in the same location, cultivation, production, and dispensary at one or more locations. And they've broken it out that way. I don't know if we're going to have any if we would need to add another class that is dispensary only. I'm not sure if that would be another category that we'd have to include. But I think that method for dealing with this, at least for this first year until we know what we're dealing with, might be the most equitable way to go. Now, I'm willing to negotiate fees within that, but I think it needs, as some of the other people in the audience have spoken, it's more prudent to vertically integrate this industry. It's more prudent for security, it's more prudent for transportation, for a variety of different reasons. And so I think to help business do business, we need to look at it in that fashion. Well, let's see. The cost of an officer is my thought process. So, city manager, the cost of an officer.
Well, when you look at the salary, PERS, healthcare benefits, I mean, you're looking at probably over 100,000 fully leveraged for a year.
What's wrong with the Reno? Oh, I see what they're doing there. The Reno or Washoe County one. Well, Washoe County's a little low there, but how about Reno or city? Yeah. I mean, they have bigger draw, but
I think I'm still going with the percentages. I believe the nominal fee, as other counties have recognized and they put into their ordinances and business license fees, if you look at this and you look at the percentages, I think that's fair, it's justable. I think you can drop the initial fee down, but keep the percentages. I know there's discussion of if that's acceptable or not, or if we can do it, but I just don't see dropping this down to the number that Supervisor McKenna stated. I think that's totally wrong.
well, it looks like we're going to make a Solomon's decision here pretty quick.
Okay, let me just make a suggestion. What if we went with, going back to the model of Henderson, the origination fee of $5,000, indemnification fee of $15,000, an annual flat fee of $30,000, an annual gross revenue fee of $50,000. That brings us to $100,000, which pays for an officer.
Are you suggesting that every license that we approve would pay for an officer?
I just think that in some way, shape, or form, we need to at least cover our expenses in some way.
In Henderson, what's the annual gross revenue fee? I mean, it says 60,000, but what does that mean?
Mr. Mayor, that's the assumption in this chart, is that this is a dispensary that makes $1 million, and so therefore it's the 6% of that. So, and keep in mind, Supervisor, about origination fee and indemnification fee are one-time fees. Yeah, just, I wasn't sure if, because I was confused by that. So, that's where that number comes from, is a $1 million.
Doesn't the city of Reno's fees kind of split the baby on that stuff then?
City of Reno is a flat rate.
That's what I mean.
Fee,
I
so,
got where Jim's going. But for the ancillary issues that we've talked about earlier, I wouldn't necessarily disagree with you, but it seems to me that, we're at 10, we're in 125, and if we pick Reno, we're in the middle, and it's kind of next kind of in our area here.
The only thing to think about with that, Mr. Mayor, is
Yeah,
that
cool.
Reno is a one-time origination fee of $40,000. So the only thing that's ongoing is the $20,000. I don't know if that's material to your analysis, but.
Yeah, I got that. Actually, you know what might make sense, I don't know, but maybe you want to flip those and say the origination fee is 20 and the annual flat fee is 40,
I think that makes much more sense because you have a new business.
and then just flip all those. And then do the change to the ordinance language. That way, you know, we're close to what Reno's said. And while we're here, anybody want to while we're talking about it, come on up and talk so we don't, come on. Hi, Mark.
Thanks again, Mr. Mayor. Mark Turner for the record. If I could just make a brief suggestion here. If the magic number to add an additional officer on the Carson City Sheriff's Force is $100,000, we could probably work the math backwards on that. But one thing I'd like to take into account is that the big difference in valuation of the different business functions of the three types of entities. The dispensary is more than likely going to be the most profitable type of operation, followed by the cultivation. And the production really is not that big of a deal. I mean, you're just not going to generate a lot of revenues out of production. So if we could weight these things based on that and still come up with the same number at the end, that would be a better idea. For example, if there are going to be 2 dispensaries, 2 cultivation operations, and 2 production of edibles in Carson City, and the magic number were $100,000, I might suggest $30,000 for the dispensary, $20,000 for the cultivation, and $10,000 for the production of edibles, and together you have $100,000. If we could come up with some sort of spread like that, it would be more appropriate to the revenues generated by each one of those businesses. Thank you.
And that would be so that would be, if on a vertically integrated company, then what would that be? 60,000 each?
60,000.
60,000, so there'd be, and assuming that we don't know how many cultivation entities or production entities will be here. Okay. John, you want to try another shot? What do you got?
No, I was just curious if we're going to fund an officer or 2, then are we going to dedicate them to these functions? Or is this just a way of determining how much revenue we want from this particular business? I have to be careful what I say because I don't want to create a record, but there's been no record established that these businesses are going to cost Carson City anything, or any more than having a new 7-Eleven open up. But we're talking massive amounts of money. I don't like fear-driving decisions.
John, it's just a base for trying to establish fees, not the necessity of having to employ another officer with regards to this.
Just a method of calculation. That's all it is. No, nobody's going to get dedicated.
No.
So if we were to use the Reno, I mean, just for talk, maybe to see if we can, if we were to use Reno, Mark, come back up here and tell us what you would, if we flip the annual fee to, if we flip the origination fee, well, take the dispensary there. If we, are you with me there? Get it.
I guess my question, do we really need origination fees, and, you know, did they have to be there, or does it just make sense to have one fee that's the same thing every year and that you know that you're going to pay this amount every year? I'd be willing to listen to anyone who thinks that you need an origination fee or an indemnification fee and then subsequent fees after that.
So you'd be okay then?
I'm more of I'd like to simplify things and not have multiple categories of fees unless.
So what if you said it was, so what if you said it was 40,000 then? Across the board, dispensary, cultivation, production, laboratory.
Are you talking about for
Yeah,
one?
I'm just trying to look at the Reno, and you just mentioned that you wanted one fee. I mean, I'm just trying to come to it.
Yeah, I'm not sure why these municipalities haven't seen the difference in between the different types of entities, because they are different and they produce very different streams of revenue. And everyone that I've spoken with would agree that the dispensary is a more valuable entity than the cultivation, which is more valuable than the production. And I think that the fees should be tailored to the revenues that each one of those businesses can generate. The dispensary most likely will generate the most revenue out of those three, followed by the cultivation and then the production. If the fees are the same for the production as they are for the dispensary, then why even go into it?
So then suppose we did this, I mean, just, this is kind of an awkward way of doing business, but, you know, we all got the dartboard out and we're just trying to operate kind of in a vacuum. But suppose you said, okay, flat fee, flat fee, dispensary 40,000, cultivation 30,000, production 20,000, laboratory 10.
That sounds like a fair layout. If anybody in the audience disagrees, but I feel that would be fair to stage
So it'd be
it like
40,
that.
30, 10, 40, 30, 20, and 10.
I would support
Annually.
That would be an annual flat fee.
Annual flat fee,
Now, would we revisit this in a year?
yes.
I think it has to be, because if there are issues that are being created that affect Neil's office, then they need to be addressed.
Yeah,
And if there's not, if we find out as you get into this that we were maybe overestimating the concerns, then changes can be made along those
Okay, we'll
lines.
make it 1 year. If this flies, we'll make it 1 year, subject to review at the end of 1 year.
That's fair.
And then with the knowledge that this stuff can either go up or down.
That's fair. That's fair.
How would we know if it goes up or down? How are we going to know?
We're going to have to make a judgment call again at that time about, you know, what we think the incremental impact has been on things caused by this to our community. That's, you know, we had to have more cops out there. You know, we had more treatment facilities that have been associated with just this entity, and it's going to be hard to figure that out because for better or for worse, there's marijuana on the underground around here. But there's going to have to be some analysis of what the incremental impact has been by licensing these entities.
And I would think that statistics from the Sheriff's Department should be readily available within a year's time.
If I'm understanding this, I just want to make sure, origination fee is 40,000?
No origination fee.
No origination fee.
Just a single fee every year.
Okay, wait. Bear with me, everyone's jumping in.
Sure.
So, no origination fee. Dispensaries is going to be 40,000, correct?
40,000 for a dispensary,
30,000 for
a
the
cultivation,
cultivation,
20,000 for production.
Production, and 10 for the
10
laboratory. Thank you.
Subject to review at the end of 1 year?
Subject to review.
Okay. I mean, that's a thought, guys, so.
Thank you.
John?
Mark, before you sit down, so these are going to be vertically integrated businesses, so the cultivation facility is going to sell to the dispensary, and they're going to be owned by the same people, or?
Well, I think that not all dispensaries will be able to be aligned with one particular cultivation unit that's going to produce the entire range of products that needs to be produced. My understanding from my colleagues is that most dispensaries in the Sacramento and the San Francisco area carry between 25 and 35 different types of plant material, and that very few, if any, cultivation operations produce all those varieties. So as a dispensary, if you need to offer that variety of products to the patients, you're probably not going to find one cultivation operation that does it. So there's going to have to be some trading of product. Otherwise, Dispensary A will carry the 6 or 7 products that they can grow themselves if they're vertically integrated. Dispensary B may not be associated. The gentleman back here said he didn't plan on opening a cultivation operation. So you probably will have to obtain some products from some other sources, and there will be intertrading of products from what I understand.
Thank you.
Bill, did you want to say something?
Thanks, Mark. I'm going to
Thank
drop
you.
it.
Have we lost, Bill Meyer, thanks, Mayor. Have you lost sight of the fact that there's sales tax too? There's, you know, that's where it's going. If you get to $5 million operations, you're talking $500,000 in sales tax. That pays for a lot of officers. A piece of the sales tax comes.
I think, and I don't know what, I guess there's a sales tax on the product, but only 2% of that 2% of the, is it 2 or 2.25? 2.25 goes to the city, the rest is to the state or other entities.
Right. Yeah, that's pretty much the way it is in Arizona, too. We have a 10.2% sales tax, which has recently gone to 9.2 because Arizona lowered their sales tax, believe it or not. City of Glendale is 2.9%. That 2.9% in 22 months has approached $200,000. So that's a pretty significant number if we ever get there with 7,000 cards. We may not get there with, businesses might fail if the fees up front are too expensive. So I would like to see them lower. I would like to be a good corporate citizen, and I'd like to pay, a reasonable number, but I can't go broke in the first 6 months. We got a $1 million commitment to build out a cultivation. And if you start stacking these fees on top of the state's got $35,000 now on dispensaries. We're aware of that, right? That's their dispensary fee. The cultivation fees are way out of whack. They're like $5,000. And they should have those flip-flopped, in my opinion. But anyway, I'm coming totally at it from a patient perspective. And I want to see these patients get their medication $55 an eighth. If they can do that, they'll be happy and probably won't go underground. So I hate to keep reiterating the same point, but I would love to pay $500,000 in sales tax, and do $5 million and have $200,000 of that come to the city of Carson City. I don't think it's likely, but just food for thought.
Bill,
Thank you.
Bill, before you go,
Yes.
I have a theoretical question for
Yes.
you, and any other applicant that wants to answer this can come up and answer it. If we, and this is theoretical, if we approved a percentage fee for a business license, would you consider 5% to be exorbitant or reasonable?
If it's an add-on on top of the proposed fees?
No,
okay.
in place of.
I would say that'd be fair, because that
Okay.
way we could manage our cash flow and stay in business while we're trying to create product and create a business. 5%'s not out of line.
Okay, and I'm not proposing that we go with a percentage, but it gives us another basis to calculate what these fees should be on a flat rate based on what we've heard from applicants as their initial revenue projections for year one.
Yep. Yeah, I don't have a problem with that. If you do go to these fees, there's one other recommendation I might have, and it might cause a little accounting problem, but if you go to $40,000 per unit or whatever the number arrives at, maybe that could be staged in and paid monthly. Gives us a chance to cash flow. Thank you.
Thank you. All right. Well, we're not too far off. Okay. Peter?
Thanks, Mr. Mayor. Peter Kruger for the record, Nevada Medical Marijuana Association. I think the thought of doing away with an initiation fee or just a startup fee is a good idea. The numbers still seem a little high to me regarding the question about a percentage. In general business licenses, there's a flat number. It happens to be in where I come from, in the city of Reno, for a business license. They use $100,000, and that's probably low, but then it's a percent so everybody pays on, based, not the fee's not $100,000, but there's a fee based on $100,000 of gross receipts, and then it's a percentage going up from there, and it's but 5% sounds a bit high to me, but nevertheless, I think the best thing is you move in the right direction. You give it a chance. Let's see what happens. I think we'll be lucky to have a dispensary open, or actually any of the MMEs open and operating more than 6 months at the end of 1 year, 12 months. Just my thought.
And again, I wouldn't say that I was promoting going to a percentage rent, but we've heard two applicants say one budgeted $500,000 in revenue for year one budgeted $750,000. If you take 5% of that, that's $25,000 to $37,250. So it gives us a basis to come back and reconcile what's on the table with what a 5% fee would be based on the numbers that we've been given by the applicants themselves.
They're talking revenue. I've talked to a couple of people in this, and they are budgeting $1 million startup. $1 million that takes care of the state fees, which we heard is $5,000 to $30,000, and then $1 million for the first year to get a vertically integrated operation up and going. That's the cost side of it.
Hi, Andy.
Hi. Andy Wilson, NAI Alliance. That would be my concern too, is basing it on the gross. Then it makes about as much sense as question number 3. So it's this, don't get me started. So if you end up, if we can agree that the gross sales will be 500 to 750, and the operating costs, let's just say they're 75%, which in the first year, the operating costs are going to far exceed. It makes more sense to start low and go high, because typically, I mean, you guys are great, but you don't always reduce fees, so I'd rather see you start low and then increase. I'm trying to be nice. So there you go. Thank you.
Andy, before you go, do you have any idea what the gross margin is on this operation? Are they going to make 50% of sales? Are they going to make 20% of sales? What's their net profit from the sale?
After they're established in year 3, somewhere in years 3 to 5, it should be about 20 to 30%.
So if they bring in $1 of sales, they're going to keep 30 cents to pay their heat, light, power, rent, profit, risk, interest, and we're going to get 5% of the gross?
I hope not.
All right, I think that's what Andy's trying to say is, don't go down that road. I got you.
Thank you.
Well, okay, Mark.
One last comment, and then I'll shut up.
Don't worry about it.
There hasn't been any discussion about when the fees start becoming applicable, and we'd like to make sure that those fees are applied at the time the thing starts operating, that we're not paying business license fees for months and months and months while facilities are being built and tenant improvements done. So I don't know if there's any way to take that into consideration, but I think it should be.
I'll propose a rent holiday that you don't pay your fees until 3 months into operations.
That would be wonderful. Thank you.
The business license fees are set up so they don't have to pay. They don't have to have a business license to be under construction. They have to get the business license to start only when they're going to start business.
Right. Okay.
Daria Shoemaker, for the record, I believe that number was misperceived when we are throwing out the gross number. We're actually not making any money the first 2 years because of the overhead costs and build out of buildings and remodeling. Not until the 3rd year on will there be a profit.
Okay. So I think what we're looking at, Kurt, come on up. Kurt, go ahead.
Running a business for 38 years, startup costs are killers. In our budget, we didn't get a profit in our submittal until the 3rd year, or about 3 years into our projected business plan. The other comment I want to make is that, remember, there's only going to, how do I put it? The only given that's known is there are only going to be 2 dispensaries in Carson City, 2. The other facilities, you don't know, but those you do know. So when you start working these numbers around, the given number is 2 dispensaries. The other ones are unknown. Thank you.
Okay. Well, I'm okay with what just said, but I think, if you want to even reduce it further, you just pairing off with what City of Reno did, and then granted, they got maybe a little bigger market, maybe you want to go 30, 20, 10, and 5, or stay at the way we said. I mean, we could do it 40, 30, 10, and 10. 40, 30, 20, and 10.
Which is what you propose.
Yeah. But you guys, I mean, that's, it's a dart, and I understand that, nobody's going to know what it is, and I guess from a pure economic standpoint, what you do is start out at zero as a license fee, because you don't know what it is. Anybody want to start out at zero? I'll tell you what, I'll give you this, I'll give you a zero plus a tax holiday. Jim, sorry.
If I may propose some dollar amounts for each one. On dispensary, I'm proposing $50,000, on cultivation, $25,000, on production, $20,000, and on the laboratory, $5,000. I came to the table with something.
Well, you're at the table. I agree. No, we're all at the table here. Okay.
Next question.
Go.
On question 3, I think there's a limit on the amount of net on the tax. Am I right on that? In other words, it's so much of the gross, but you're limited. If you don't make a profit, you don't have to pay any tax?
No, that's not true.
Not true? Okay. Are we going to have a similar thing? You pay this fee no matter whether you make a profit or not in the first year?
Yeah.
Okay.
Well, I'm still okay with John's original proposal.
I'm warming up to it.
You ready to try motions?
Yeah, well, I'm going to try mine out here. It's got the chair, so I've got the microphone. I'm going to say that we set a dispensary fee of $40,000, a cultivation fee of $30,000, production fee of $20,000, laboratory fee of $10,000, and it starts upon first day of opening the doors, and that we make the changes suggested to the whereas clauses on the ordinance. These are annual fees, and that it be reviewed at the end of 1 year from the date the ordinance goes into effect. Any seconds? Getting to feel like you, Jim. No second. Okay.
Held
All right.
it. Okay, I just want to clarify. You had 40,000 in dispensaries, 30 on cultivation, 20 on production, and 10 on the laboratory, correct?
Correct.
I will second your motion.
Okay, there's a second. Discussion? Hearing none, all in favor signify by saying aye.
Aye.
Aye. Opposed?
Nay.
Motion fails. Try another one. John, make your motion.
I'll make my motion.
Oh, make your motion. Go ahead.
I propose a dispensary fee. Sorry. It goes off by itself. Dispensary will be 50,000, cultivation 25,000, production 20,000, laboratory 5. I second yours, Mayor.
Second.
I'll second that, but you know what? If mine didn't pass and yours does, I'm really going to be aggravated, man. I'm really going to be aggravated. Okay, on the motion. Discussion, hearing none, all in favor signify by saying aye.
Aye.
All opposed? No. I should say, okay. All right. Another motion. It's a good shot. All
All
right.
right, I'll make a motion to incorporate all the mayor's comments except for the fee portion of it, which shall be, I'm going to go with $25,000 for a dispensary, $20,000 for cultivation, $15,000 for production, and $5,000 for a testing lab.
I'll second that.
All in favor? Signify by saying aye. Aye. Opposed?
Nay.
Motion passes. How about that? Solomon Bunkowski. All right. We got enough direction to the staff?
Lee, can you read that back, just for confirmation, what you have there?
So with regard, With regard to the fees, it will no longer be a structure as is up there based on size. It's going to be modeled more on the Reno model in terms of the breakdown for dispensaries, and a flat annual fee for dispensaries, $25,000, for cultivation facilities, $20,000, for edible production facilities, $15,000, and testing laboratories, $5,000. Correct?
And may I ask, Lee, could you, your PowerPoint presentation, could we also get that emailed to us or put on the website for accessibility? Thank you.
You got enough, or do we need to clarify some other issues?
I think we've all kind of reached that point, Mr. Mayor.
Well, it's 5:30, we can always wait. We'll take a recess, eat dinner, and come back and talk. But no, all facetious aside, I appreciate everybody putting up with this, because this is, one is how democracy works, but two, we're kind of operating in a vacuum. But the other thing that we have to make sure of is that we've heard that the state's going to be issuing its licenses in November. We need to get this cranked up in October so people know where they are.
And we fully intend to. We'll be back with the first reading of this ordinance, and we'll be able to meet that timeline unless something unforeseen happens. We should meet that timeline.
Okay. All right. Anything else to come before the board? Are we ready to adjourn, everybody? Public comment, concluding public comment, anybody? Okay. Hearing no comment, we're adjourned.